Hello, everyone, and welcome to an all special edition of Uncivil Law. I hope you, as always, are having the very greatest of days. And we are here with Watch Unky Blackleaf Suffer Stream. We're doing a double header. We're doing Auer and Brand X. This is a thing that's happening. And you'll be happy to know this time I have a friend. Today's friend is a mixture of amaretto and Bailey's with a sprinkling of cinnamon. And it's a double. So I am well prepared for this. So I suppose we will get started with Auer versus Robbins. This is Auer versus Robbins, U.S. Supreme Court, 1997. And I'll read you the facts of the case. This is a unanimous decision by the United States Supreme Court, by the way, just like Chevron was, although this is 9-0. Here are the facts of Auer. Francis Bernard Auer, a St. Louis police sergeant, other St. Louis police sergeants, and a lieutenant, sued the respondent police commissioners, including David A. Robbins, for overtime pay under the Fair Labor Standards Act of 1938. The commissioners argued that Auer and other petitioners were bona fide executive, administrative, or professional employees exempted from overtime pay requirements by the FLSA. So, Fair Labor Standards Act requires overtime pay for your line workers and doesn't require overtime pay for your management in the broadest strokes. They're arguing it's management. Fine. Under the Secretary of Labor regulations, that exemption applies to employees paid a specific minimum salary on a salary basis, which requires that the compensation not be subject to reduction because of variations in the quality or quantity of the work performed. They're on salary, not hourly. Auer claims that they did not meet this test because, under the terms of the police department manual, their compensation could theoretically be reduced for a variety of disciplinary infractions related to quality or quantity of work. The District Court and Court of Appeals disagreed with Auer's claim. Both courts held the salary test was satisfied. Thus the question: must sergeants and lieutenants in the St. Louis Police Department be paid for working overtime pursuant to the Fair Labor Standards Act? And spoiler alert, the answer to the question is no. But that's not why we're here, of course. We're not here because the Supreme Court said these people don't get overtime. That's not what makes this case interesting. Any more than what made Chevron interesting was a disagreement over what counts as a source. Oh yeah. Right? Do I have a super strong opinion as to whether or not St. Louis police sergeants and lieutenants should get overtime pay or not? I do not have a strong opinion on this issue. I don't know. I frankly don't really care that much. Give them overtime or not. It's not, whatever. That's not why we're here. That's not why we're here. We're here because this decision is going to say that agencies get to interpret their own regulations. In this case, the Secretary of Labor's regulations, interpreting the Fair Labor Standards Act. So let us start with the oral argument and listen to oral argument that doesn't really matter because it's not about the issue. And if there's anything to say, I guess we'll say it along the way. So let's see how this goes, I guess. Here we go, kids. Unky Blackleaf is in a mood.
Francis Bernard Auer versus David Robbins.
Anytime. While we're young. Matt, like that question matters. Psh. Like that question matters.
Mr. Leavings, you may proceed whenever you're ready.
No. The answer is no, Matt. Nope.
Mr. Chief Justice, and may it please the Court. This case involves the application of a rule in the Fair Labor Standards Act dealing with the salary basis test. The rule is contained in 29 CFR 541.5D and 541.118. The rule basically provides that for persons to be considered white-collar exempt, that is exempt administrators, or exempt executives, their salary must be fixed and not contingent. The specifics of the rule provide that they must receive a predetermined amount, not subject to deduction because of the variations in quality or quantity of work.
I've noticed with interest that the federal government does not follow the salary basis test for employees that are under the jurisdiction of the Office of Personnel Management. It chooses not to go along with that at all.
Well, it attempted to choose not to go along with that at all. In 1975, I believe, when the federal government first came under the Act, Congress provided that the Fair Labor Standards Act would be enforced by the Office of Personnel Management, but that would still be defined and delimited by the Department of Labor. And when the Office of Personnel Management initially issued regulations for the federal sector, they defined exempt status for salary purposes based on salary classification. But that definition was challenged in court in a specific case involving Uniform Division of Secret Service police sergeants and lieutenants. And the Court of Claims in that case specifically found that the enforcement by the Office of Personnel Management has to be undertaken consistent with the Department of Labor regulations, because it's the Department of Labor that defines and delimits exemption.
And now are all federal employees applying this salary basis test?
Well, first of all, the Court of Claims found that to be the case. They found it, and they also found it in some other cases involving the AFG case, which is cited in the brief. And currently, the position in the Department of Labor, the position of the federal government is that the Office of Personnel Management often treats people as exempt even though they're not salaried, but the Court of Claims in the United States Court of Appeals for the District of Columbia have held that they should apply the salary test. And when that has been a challenge, and the one place that's been challenged specifically is in the Uniform Division of the Secret Service, and for employees that do the exact work of the employees in this case, that is sergeants and lieutenants in the Uniform Division, and the court ruled that the Department of Labor pay classification things have to be applied consistent with the salary base.
Justice O'Connor was not asking about court decisions. She was asking about the position being taken by the executive branch.
I believe the Office of
and OPM takes a different view.
The Office of Personnel Management takes the position that federal employees can be exempted based on pay classification alone. I do not think that, and I think that the courts have found that to be the case, and I don't think it's consistent with the statute. For example, when Congress passed the statute applying the Fair Labor Standards Act to themselves, they did apply the salary basis test to themselves. And under the Congressional Accountability Act, the regulations under that act specifically say that the salary basis test does apply to congressional employees. And it specifically includes the regulation, including there was some discussion in the comments on the regulation of whether 541.5D which is a special rule limiting part of it, I'll talk about in a minute, how that should be dealt with by the Congressional Accountability Office. And after considering the comments, they included the regulations and specifically made reference to the applicability of the salary basis test to congressional employees. So, and in addition to that, in the record, there's a history of the Department of Labor's current consideration of the regulations. And as part of that history, the director of the OMB has had a series of reports and considerations with the Department of Labor about this problem and how to deal with it in the future. So the answer is the Office of Personnel Management, just like a lot of employers in a lot of places, claim that they can exempt people based on classifications alone. But when the federal government and when the Congress have looked at it, they've said they have to
Well, they also have a regulation saying the federal government can
Midnight
dismiss,
Rose, you have no idea how
suspend
much I'm on
employees
board
for
with
14
you.
days or less.
I have also very much tried to
Right,
refrain
by way
from
of
saying it.
discipline.
they have a regulation.
Believe me,
Yes,
I
that's
was
true, they
thinking
do.
the exact
And
same thing.
And the question that raises the question of whether that would make all federal employees subject to that rule, which doesn't cover all federal employees, but I think it covers all federal employees in classified service, non-exempt. And I think that is part of the struggle the Department of Labor has had, and that is why the Department of Labor has had the practical rule to the long-standing salary basis test, and I think I can explain how the practical rule, I think, works. But if you look at, and we attach the Department of Labor briefs going back from 1981 and their positions, there has been some development.
Also, why does his audio sound like it was recorded with technology 30 years older than the technology used to record the justices? This is something I'd like to know the answer to.
And how you deal with the problem where there's a rule on the books that seems counterintuitive, how can an employer apply that rule? And I think the rule that I would argue is that the first rule of the regulation, and after all, the Department of Labor that issued this regulation issued it under a direct rule of Congress, is that the employee's salary must be fixed and immutable. It cannot be contingent. An exempt employee cannot have contingent income. And that, however, that is the test. And then, however, there can be a situation where there are rules on the books where people have a rule that says you can be subject to discipline for 14 days, which would be longer than a work period, so that would be okay. But if under that rule they discipline somebody for 1 day, which, by the way, the statute, the federal regulation doesn't say they would do, but if they did do it, that would raise a question of whether the people were practically subject to deductions for less than a full work period. And I think in that case you'd have to prove if all you had was a rule and the employer claimed that the people were exempt and that they were not doing deductions. I think the burden's on the employer to come forward with some evidence. They at least have to assert that we would not punish anybody for less than a pay period, which the federal government could do in a given case.
Of course, here.
Again, I don't particularly care about the issue that's being decided. It's not, in my humble opinion, that big a deal. It affects a lot of people, but like, all right, so we got two classes of workers. We got exempt and non-exempt workers, right? So non-exempt workers are your entry-level people. Hourly pay is typical your indicator, and their pay is variable on how many they work. So if they work overtime, you have to pay them overtime wages. Exempt people are typically management. They are typically on a salary, and their salary is not dependent on it. And as a result, you don't have to worry about minimum wage rules if you're paying them a salary, and you don't have to worry about overtime if you're paying them a salary, and so forth and so on, all the rest. All right? So we've got two universes of people. Non-exempt, your worker at your fast food restaurant. Exempt, his boss, right? Fine. So we've got some random police people, some sergeants and lieutenants. Now, I have no idea, even beginning, how St. Louis structures its police system. All right? Every police system is a little bit different, so I don't know what these terms mean or imply in St. Louis. I have zero clue. I don't know if they're management, in fact, or not, based on their description. Could be. I don't know. Could be. So, if it's me as a court just trying to figure it out, like, look at the indicators, apply the test, and figure out which category they're in. Right? But no, what we're going to do instead is we're going to say, Department of Labor gets to create this and interpret their own rules. So, yeah.
You're asserting, I guess, that because of one instance involving one sergeant, that all the other people who have never been disciplined fall under some non-exempt status.
I am
just on the basis of some possibly broader state rule applicable, or county rule, or police department rule.
I'm asserting that all sergeants and lieutenants in the St. Louis Police Department, whose pay is contingent, and who all the witnesses, including the chief of police, including everyone who testified, no one ever testified that any sergeant or lieutenant's pay was not subject to discipline. No one not only didn't testify, but no one even ever asserted that. I did not rely on Mr. Gussie. It isn't because Mr. Gussie received 1-2-day suspension that transferred all of the employees from having contingent pay to non-contingent.
Well, it's what it looks like, because it didn't happen to anybody else in the numerous plaintiffs here, did it?
I'm sorry, it did. There is evidence in the record that it did happen to other sergeants. In fact,
no, Janice, salary does not imply a 40-hour work week. No, it doesn't imply a 40-hour work week. And I can testify to that with some experience, because lawyers who are almost inevitably salaried, especially at big firms, do not work 40-hour work weeks. So no, salary does not imply a 40-hour work week. You get so much pay for so much work, and if you work more than 40 hours, you get paid exactly the same. So, yep.
And in fact, it did happen to other sergeants. What's not in the record is an example of a specific sergeant who testified that he was suspended. But the reason for that is, if you look at the whole record, the case was bifurcated and it was tried on the basis of representative witnesses. For example, there was only one witness that testified that he was a homicide detective.
Well,
and yet all the homicide detectives...
The Eighth Circuit, as I read its opinion, said that a one-time suspension without pay for violating the city's residence requirement doesn't mean that the whole thing is over.
Right.
Now, do you disagree with that ruling?
I agree that a one-time suspension, standing in isolation, if the employer took the position that the pay was guaranteed and that was a mistake, it was inadvertent, that it wouldn't automatically mean. So a one-time suspension in one case all by itself would not settle the case. And one reason for that is the burden's on the employer in the first instance to establish.
That's my bad. I clicked away. Hold on a second. I will find the place and we will start over, or not start over, but we'll just find where we were. Close enough.
The Eighth Circuit, as I read its opinion, said that a one-time suspension without pay for violating the city's residence requirement doesn't mean that the whole thing is over.
Right.
Now, do you disagree with that ruling?
I agree that a one-time suspension, standing in isolation, if the employer took the position that the pay was guaranteed and that was a mistake, it was inadvertent, that it wouldn't automatically mean. So a one-time suspension in one case all by itself would not settle the case. And one reason for that is the burden's on the employer.
To bring it home on the hours issue, like, there's no rule on this. As I said, like, lawyers typically get salary and typically work more than 40 hours and get the same pay. But by the same token, people who sits on certain boards of directors, for example, Hunter Biden, for example. Does anyone here think that Hunter Biden worked a 40-hour work week or more to earn his $83,000 a month in Burismo? Or do you think he showed up like 1 hour a week? I'm betting it's more the latter. So there's no hour connection to salary. You can work 1 hour a week, 1 hour a month. You can work 80 hours a week and you get the same pay. Salary is just not dependent on the number of hours you work. It's dependent on your job role and dependent on the work you have to do. So it has nothing to do with hours. You can work 1 hour a month and work for Burismo, or you can work 100 hours a week and work for a law firm. Your choice.
In the first instance, to establish the employees are guaranteed a predetermined amount of pay. One instance of somebody losing a guaranteed amount of pay would certainly raise a lot of suspicion. But if the employer were in some case, in a given case, for instance, to claim that was a mistake, it wasn't under the rules, that different. But in our case, the chief of police, the 30B6 designees of the employer for exempt status, and for application of the regulations. And everyone else testified that, in fact, all sergeants were subject to being disciplined. And there is repeated evidence in the record
What evidence in the record of actual discipline other than this one sergeant?
There is, at page, the chief of police testified that all sergeants were subject to suspension.
Yeah, but that wasn't my question. I asked you, what evidence is there in the record of actual discipline, not whether someone is subject to discipline?
For instance, Sergeant Michael Fredericks testified that he knew of sergeants that were suspended for less than a day. In the record, there is no other name of a specific sergeant that was suspended. But there is a great deal of evidence that, in fact, other sergeants, other than Mr. Gussie, were suspended.
Yeah, but the 8th Circuit didn't find for you as a fact on this point, did it?
Because the 8th Circuit did not agree with the base rule. A, they didn't agree that the burden was on the employer to establish that pay was fixed rather than contingent, and B, they put the burden on the plaintiffs to establish actual instances of deduction, which I don't think they should have done. But looking at all the evidence of the record, no one could conclude from the evidence of that record that the regulation which says pay is not subject to deduction was followed in this case. I mean, it'd be different and there are cases that are reported.
All right. I've ceased to care about this oral argument. I cease to care about the oral argument because the issue they're talking about is not the issue that's being decided. Once again, much like Chevron. So we could go on arguing about whether these people are exempt or non-exempt. But that's not the issue, is it? That's not why we're here. So let's just stop talking about this and let's pull up the case. Let's read the decision. How about that? Let's do that. So we're going to do that now. My channel. All right, let's read this bullshit. Let's read this bullshit together. Let's read this bullshit from 1996. This is Auer versus Robbins, the decision. Unanimous. We're going to read this. That's what we're doing now. We could go through the oral argument. Does anyone care? No, because it doesn't matter. The oral argument doesn't matter. The issue doesn't matter. That's where we are. The issue doesn't matter. It doesn't matter whether they're exempt or not. That's not the relevant issue. All right, I'm gonna skip the summary because we're just gonna read the full fat opinion. So this is Scalia writing this. Great. Yeah, the ears thing also was a major factor, Midnight Rose. I couldn't bear to listen to it any longer either. So I'm not going to lie. That was also a major factor. I just could not bear about it anymore. Yeah. All right. Justice Scalia delivered the opinion of the court. The Fair Labor Standard Act of 1938, as amended, exempts bona fide executive, administrative, or professional employees from overtime pay requirements. This case presents the question whether the Secretary of Labor's salary basis test for determining an employee's exempt status reflects a permissible reading of the statute as it applies to public sector employees. All right, so if you're on salary, you would be exempt definitionally. That is the argument. We also consider whether the Secretary has reasonably interpreted the salary-based test to deny employee salary status, and thus grant him overtime pay when his compensation may, as a practical matter, be adjusted in ways inconsistent with the test, which is like this penalization thing, whatever. All right, let's talk about the facts. Not that it matters, but let's talk about the facts. Petitioners are sergeants and a lieutenant employed by the St. Louis Police Department. They brought suit in 1988 against respondents, members of the St. Louis Board of Police Commissioners, seeking payment of overtime pay that they claim was owed to them under the Act. Respondents argued the petitioners were not entitled to such pay because they came within the exemption provided by the law for bona fide executive, administrative, or professional employees. Fine. Under regulations promulgated by the Secretary, the requirement for exempt status under the law is that the employee earn a specified minimum amount on a salary basis. According to regulations, an employee will be considered to be paid on a salary basis if, under his employment agreement, he regularly receives each pay period on a weekly or less frequent basis a predetermined amount constituting all or part of his compensation, which is not subject to reduction because of variations in the quality or quantity of the work performed. Salaried. Petitioners contend that their salary basis test was not met in their case because, under the terms of the St. Louis Metropolitan Police Department Manual, their compensation could be reduced for a variety of disciplinary infractions related to quality or quantity of work. Petitioners also claim they did not meet other requirements for exempt status under the law, that their duties be of an executive, administrative, or professional nature. At this point, you can argue amongst yourselves whether or not what police do is to be considered of a professional nature. The district court found that petitioners were paid on salary basis and that most, though not all, satisfied the duty criterion. The Court of Appeals affirmed in part and reversed in part, holding that both the salary test and the duties test were satisfied as to all petitioners, and we granted cert. Fine. The Fair Labor Standards Act grants the Secretary broad authority to define and delimit the scope of exemptions for executive, administrative, and professional employees. Under the Secretary's chosen approach, exempt status requires the employee be paid on a salary basis, which in turn requires his compensation not be subject to reduction because of variations in quality or quantity of the work performed. Yeah. Because the regulation goes on to carve out an exemption for this rule for penalties imposed for infractions of safety rules or of major significance, it's clear the rule embraces reductions in pay for discipline violations. Well, presumably for the class just delineated, but okay. The Secretary is of the view that employees whose pay is adjusted for disciplinary reasons do not deserve exempt status because, as a general matter, true executive, administrative, or professional employees are not disciplined by piecemeal deductions from pay, but are terminated, demoted, or given restricted assignments. Okay, whatever. Respondents contend the district court lacks jurisdiction over the petitioner's suit by virtue of the 11th Amendment. We've covered that a little bit before. The Board of Police Commissioners, however, does not share the immunity of the state of Missouri. And that is very, very true. This has been established. I don't know if it was established in this case or established elsewhere, but the 11th Amendment deals with states, not subordinate entities. So the 11th Amendment only covers the state of Missouri, not any sub-entity within them. So like the city of whatever does not get 11th Amendment protection, only the state of Missouri. That's how that's been interpreted, which kind of makes sense under federalism-based issues. The idea of the state as a whole being sovereign makes sense, and the state being able to pierce that to the lower levels, it's not the same thing. So it's a reasonable interpretation, I suppose. The Board of Police Commissioners, however, does not... While the governor appoints 4 of the board's 5 members, the city of St. Louis is responsible for the board's financial liabilities, and the board is not subject to state direction or control in any other respect. It is therefore not an arm of the state for 11th Amendment purposes. I would tend to agree that that's probably true. The Police Department of St. Louis is probably not an arm of the state. That's probably reasonable. It's an arm of St. Louis, but that's a different entity, so that kind of makes sense. The Fair Labor Standards Act did not apply to state and local employees when the salary basis test was adopted in the 1940s. In 1974, Congress extended the coverage to virtually all public sector employees. And in 1985, we held this exercise of power was consistent with the 10th Amendment. Not that anything has ever not been, right? The salary-based test has largely existed in its present form since 1954, and is expressly applicable to public sector employees. Respondents concede that the Fair Labor Standards Act may be validly applied to the public sector, and they also do not raise a general challenge to the Secretary's reliance on the salary basis test. They contend, however, there are no disciplinary deductions element of the salary basis test is invalid for public sector employees because, as it applies to them, it reflects an unreasonable interpretation of the statutory exemption. That is so, they say, because the ability to adjust public sector employees' pay, even executive, administrative, or professional employees' pay, as a means of enforcing compliance with work rules, is a necessary component of effective government. In the public sector context, they contend fewer disciplinary alternatives to deduction of pay are available. To me, that's a weak sauce argument. Like, it's either in the statute or it's not. It's either available as an exception or not. That it's really, really painful to us is not a valid argument in this jurist's humble opinion. To me, it doesn't flow. But the court is going to tell me why I'm wrong. Yay. Because Congress has not directly spoken to the precise issue, we must sustain the Secretary's approach as long as it's based on a permissible construction of the statute, citing Chevron, which we covered last time. Yay. While respondents' objectives would perhaps support a different application of the salary-based test for public employees, we cannot conclude they compel it. The Secretary's view that public employees are not so differently situated with regard to disciplining their employees as to require wholesale revision of this time-tested rule simply cannot be said to be unreasonable. I just don't think that's the test at all. I think it's completely the wrong test. That's what Chevron implies, but I don't think that's the right test. I don't care whether your interpretation is reasonable or not. I care if it's the correct interpretation of the statute. I care if it's the correct interpretation. That's what judges do. Interpret the law and tell you what it means. So, question isn't it reasonable? Question is it right as far as this man is concerned? We agree with the Seventh Circuit that no principle of public administration that has been drawn to our attention makes it imperative that public sector employees have the ability to impose disciplinary pay deductions on individuals employed in genuine executive, administrative, or professional capacities. Fine. Respondents appeal to the quasi-military nature of law enforcement agencies such as the St. Louis Police Department. The ability to use a full range of disciplinary tools against even relatively senior law enforcement personnel is essential, they say, to maintaining control and discipline organizations in which human lives are on the line daily. Well, that's a very good policy-based argument. I'm not even saying you're wrong in your policy-based argument. In fact, I think many people who are watching this stream would be quite pleased if police departments would take care that their own people are enforcing the law with better attention. So I'm not saying that you shouldn't view this as military or quasi-military. In fact, that would probably help quite a lot. But I am saying that it is either compliant with law or not. For that matter, lest I miss the point, the entire U.S. military is likewise subject to statute. Congress is the one that creates the Army and the Navy, and they're the ones that pass the rules and regulations and allow it to exist. Congress can at any time enforce any rules it wants on the military at all, because it's Congress's agent, and so they can set up rules and regulations, all kinds of shit. So if they were to pass a regulation somewhere that said, hey, if privates work more than 40 hours a week, they have to get overtime pay, guess what? Privates have to get overtime pay now. So if the St. Louis Police Department is subject to this law, quasi-military or actual military or not, I don't care. They still have to comply with the law just as much as the military does. Yeah. Tasty. It is far from clear, however, that only a pay deduction and not some other form of discipline, for example, placing offending officers on restricted duties, will have the necessary effect. I don't know. If you make them do traffic duty for a while, I'll probably get their attention. Because the Fair Labor Standards Act entrusts matters of judgment to this as the Secretary, not to federal courts, we cannot say the disciplinary deduction rule is invalid as it applies to law enforcement personnel. That is not the right test. It's not the right test to wonder whether or not the Secretary was reasonable. The test is whether or not it's the law. Is it the law? Yeah. And yeah. Hagan said, what I really get is a huge increase in the number of corporals. Yes, I was making it as an illustration. So, just saying, the military actually has to follow the law too, was my point, Higgins. But thank you. The more fundamental objection respondents have to the disciplinary deduction rule is procedural. The Secretary has failed to give adequate consideration to whether it really makes sense to apply the rule to the public sector. Respondents amici make the claim more specific. The Secretary's failure to revisit rule in the wake of our Garcia decision was arbitrary and capricious in violation of the Administrative Procedures Act. It is certainly true that application of disciplinary deduction rule to the public sector raises distinct issues that may warrant the Secretary's formal consideration. This much is suggested by the veritable flood of post-Garcia litigation against public employers in this area. But respondents' claim about the failure to amend the disciplinary deduction rule cannot be raised in the first instance in the present suit. A court may be certainly asked by the parties in respondents' position to disregard an agency's regulation that is contra to the substantive requirements of law, or one that appears on the public record to have been issued in violation of procedural prerequisites, such as the notice and comment requirements. But where, as here, the claim is not that the regulation is substantively unlawful, or even that it violates a clear procedural prerequisite, but rather that it was arbitrary and capricious not to conduct amended rulemaking, which might have resulted in no changes, there's no basis for the court to set aside the agency's action prior to any application for relief addressed to the agency itself. That part is fair. Under federal law, but not necessarily under state law. Under federal law, you do have to exhaust your administrative remedies first before you can go to court. That is true as a matter of federal law, not necessarily state law. So your mileage in state law may vary, but as a matter of federal law, you have to exhaust all your administrative remedies before you can go to court. You have to give the agency a chance to fix their mistake. So that is the rule. The proper procedure for pursuit for respondents' grievance is set forth explicitly in the Administrative Procedures Act. A petition for rulemaking, a denial of which must be justified and then can be appealed to the courts. Well, as to that much, I agree. I don't really have a problem with that. Okay, you think the rule was improper. All right, fine. Go petition for a new rule, and if they deny you, then you can sue them. Not that it will help, because the case we're just deciding as we speak at this moment gives them so much flexibility. But, in theory, that's what you should do. So go do that first, then complain to us, then we'll ignore you again. Does the statute say the Secretary has that right, or is it implicated by Chevron? Who knows, Matthew? Who knows? I don't know. Yeah. You don't mean reinterpret the rule so you don't have a case. Yeah. Does it matter whether the statute actually committed it to him or whether it was inferred? Not really at this point, so pick one or the other. Either way is fine. A primary issue in the litigation unleashed by application of the salary basis test to public sector employees has been whether, under that test, an employee's pay is subject to disciplinary or other deductions when there exists a theoretical possibility of such deductions, or rather only when there is something more to suggest the employee is actually vulnerable to having his pay reduced. Petitioners, in effect, argue something for closer to the former view. They contend that because the police manual nominally suggests all department employees to a range of disciplinary sanctions that includes disciplinary deductions and pay, and because a single sergeant was actually subject to the disciplinary deduction, they are subject to deductions and therefore are non-exempt, which sounds like a plausible argument. The Court of Appeals rejected the approach, saying that the mere possibility of improper deduction in pay does not defeat employees' salaried status if no practice of making deductions exists. Fair enough. In the Court of Appeals view, a one-time incident in which a disciplinary deduction is taken under unique circumstances does not defeat the salaried status of an employee. In this case, the sergeant in question, who had violated a residency rule, agreed to a reduction in pay as an alternative determination. So he didn't live in the jurisdiction that he needed to police, which is a requirement of some places. You have to live in the jurisdiction. Not all, but some. That's a rule. So that's, The requirement of actual deductions was also imposed in an earlier ruling by the 8th Circuit and the 11th Circuit case, and other circuits have rejected the requirement. Okay. Petitioners also contend that additional sergeants were actually subjected to disciplinary deductions, but the fact is not established by portions of the record petitions cite. The Secretary of Labor, in an amicus brief filed at the request of the court, interprets the salary-based test to deny exempt status when employees are covered by a policy that permits disciplinary or other deductions in pay as a practical matter. That standard is met, the Secretary says, if there's either an actual practice of making such deductions or if an employment policy that creates a significant likelihood of such deductions. The Secretary's approach rejects a wooden requirement of actual deductions, but in their absence requires a clear and particularized policy, one which effectively communicates deductions will be made in specified circumstances. I don't really have a problem as to this sub stuff. My issue is the big issue. This sub stuff is okay, whatever. It doesn't matter. That's fine. You want to say there's a difference between a practical and theoretical? Sure. Fine. That's great. This avoids the imposition of massive and unanticipated overtime liability, including the possibility of substantial liquid damages. In situations which are vague or barely worded, policy is nominally applicable to a whole range of personnel, but it's not significantly likely to be invoked. Fine. Because the salary test is a creature of the Secretary's own regulations, this is the part. This is the part, guys. This is the part that matters, okay? This is the part that matters. If you're waiting for the part that matters, this is it, okay? This is the part that matters, so pay attention. Because the salary basis test is a creature of the Secretary's own regulations, his interpretation of it is, under our jurisprudence, controlling, unless plainly erroneous or inconsistent with the regulation. That deferential standard is easily met here. The critical phase subject to comfortably bears the meaning the Secretary assigns. That was the magic language. Those were the magic words, guys. If you're waiting for the magic words, there it was. He gets to interpret it. He gets to change it. Because it's his regulation. Okay, just I want you to fully keep this in mind, guys. The Secretary is interpreting the regulations he wrote. He wrote them. Okay? They're his regulations. And he put pen to paper and they published in the Federal Register. And now he's coming back and saying, what I actually meant by that was X. And then another secretary can change their mind, as we're going to see in Brand X in about 10, 15 minutes or so. So this is the key sentence. The Secretary's own regulations, his interpretation controls, even if that interpretation changed, unless it's plainly erroneous. And so Chevron, for you playing at home, Chevron said when an agency is interpreting a statute, their interpretation governs unless clearly erroneous. And Auer says when an agency is interpreting its own regulations, the one it wrote with its own hand, it gets to interpret them under its own interpretation too. That's what that says. That's what that says. Yeah, that's the bad part. If you're waiting for the bad part, it's on screen now. The Secretary's approach is usefully illustrated by reference to this case. The policy on what petitioners rely is contained in a section of a police manual that lists a total of 58 possible rule violations and specifies the range of penalties associated with each. All department employees are nominally covered by the manual, and some of the specified penalties involve disciplinary deductions in pay. Under the Secretary's view, that's not enough to render the petitioner's pay subject to disciplinary deductions within the meanings of the salary-based test. And Jan hits the nail on the head. It's legislative, judicial, and executive all at the same time. Yes, it is, Jan. Yes, it is, Jan. This is so because the manual does not effectively communicate that pay deductions are an anticipated form of punishment in the petitioner's category, since it's perfectly possible to give full effect to every aspect of the manual without drawing any inference of that sort. If the statement of available penalties applied solely to the petitioner's matter would be different. But since it applies to both petitioners and to employees who are unquestionably not paid on salary basis, the expressed availability of disciplinary deductions may have reference only to the latter. No clear inference can be drawn as to the likelihood of sanctions applied to employees such as petitioners. Wow, that's a really creative interpretation, guys. Okay, so I just want you to make sure that you fully appreciate what was just said. Okay, because I just want you to make sure you fully understand and fully comprehend the words that were just said. Okay, all right. So the St. Louis Police Department what is it? What was the number? 58. All right. So the St. Louis Police Department Police Manual: How to be a good police officer in St. Louis. You and policing is the title I am now giving it. Has somewhere in its manual 58 rule violations that can ascribe to you certain penalties. The way that the thing is written, it applies to everyone. All right? It applies to everyone. But so normally I would say, well, it's undifferentiated. And therefore, since it applies to everyone, it applies to these people too, right? So if you have something that says this applies to everyone and it's undifferentiated, then my conclusion would be this applies to everyone. Is that the right answer? No, it's not. It's not the right answer because no clear inference can be drawn as to the likelihood of sanctions being applied to the employees such as the petitioners. You know, just because we've applied it to other people doesn't mean we can apply it to you, even though it's undifferentiated. So it can't be inferred. This is the Supreme Court, fellas. Yeah. Matt is exactly correct. Right? So, like, especially the conservatives don't really care about, like, intent. So Matt is 100% correct. You could walk every senator into the room and say this is what they meant, and they would ignore them all. But you walk the one administrator into the room, and they're like, "Yes, tell us more." He's totally right. He's totally right. That's funny, Matt. That's a really good point. Well spotted. Nor under the Secretary's approach is such a likelihood established by a one-time deduction sergeant's pay, absent unusual circumstances. Petitioners complain that Secretary's interpretation comes in the form of a legal brief. Oh my God. Guys, I want you to really I just want you to really fully appreciate this wonderful of a sentence here. Petitioners complain the Secretary's interpretation comes to us in the form of a legal brief, but that does not, in circumstances of this case, make it unworthy of deference. Wow. 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 You know, there's this idea in law, in like normal law world. Normal law world, if you don't mention it earlier, you lose it. So if the first time they mention it is in a Supreme Court brief, it's probably a non-starter, right? Because you had to give the court below a chance, and you had to give the district court a chance. So normally this is like an issue preclusion issue, right? If you don't mention an issue, it's gone. It's gone, right? You can't bring it up again. But not here. Not here. The fact that it's in a brief, that doesn't make it unworthy of deference, even though that's like what we do like everywhere else. Normally what we do is say, just cross it right out of your brief and pretend it doesn't exist. But here we're going to highlight it instead and be like, ooh, ah. Okay. The Secretary's position is in no sense a post hoc rationalization. I'm going to have a stroke. Advanced by the agency seeking to defend a past agency action against attack. There is simply no reason to suspect that the interpretation does not reflect the agency's fair and considered judgment on the matter of the question. Man, if the agency is selling me a bridge, I guess the Supreme Court's buying, man. Woo. Petitioners also suggest Secretary's approach contravenes the rule that FSLA exemptions are to be narrowly construed against employees and are to be withheld except as the person is plainly and unmistakably within the term and spirit. Wow, I don't even know what I'm reading at this point. I don't even understand the words that I'm reading. Help me, guys, help me. Petitioners also suggest the Secretary's approach contravenes the rule that the exemptions are to be narrowly construed against employees and are to be withheld except as the person's plainly and unmistakably within their terms and spirit, citing a previous U.S. Supreme Court case. Well, geez, that sounds pretty persuasive. So what you're telling me is there's Supreme Court precedent, and what the Supreme Court precedent says is that the exemptions for exempt employees are to be narrowly construed against employees and should not apply except as a person's plainly and unmistakably within their terms and spirit. That seems pretty clear to me. Everyone is non-exempt unless they're clearly not. Clearly not. That's what the U.S. Supreme Court said in 1960. That seems pretty clear. But, what do you mean but? What do you mean but? But that is a rule governing judicial interpretation of statutes and regulations, not a limitation of the Secretary's power to resolve ambiguities in his own regulations. You know, I was under the very distinct impression that regulations had to be in compliance with statutes. That if a statute was clear, that a regulation couldn't defy it. So if it is truly the case that for the judicial interpretation of statute, that it has to be narrowly construed, if that is true, it must be true of the regulations as well, except it's not true. It's not true. Even though we have said in our binding precedent, the statute should be narrowly construed, that's no barrier to the Secretary writing regulations as broadly as he wishes. You know, that's totally not a problem for something. Someday someone has to explain this to me in easy to understand words, because I don't know, guys. I'm not. This is a unanimous opinion. It's unanimous, and so was Chevron. I mean, like, I'd like to think I'm a reasonably competent, reasonably smart guy, reasonably well read, reasonably educated, and I don't get it. I don't understand. I don't understand these things. What do you mean that this is the rule? What are you talking about? You know what? I honest to God feel like if I was a law professor and someone wrote this on an essay response, I would mark them down horribly. So, yeah. One small issue remains unresolved. Really, one small issue. I'm I have several major issues that remain unresolved. The effect upon the exempt status of Sergeant Guzzi, the officer who violated the residency requirement of the one-time reduction in pay. The Secretary's regulations provide that if deductions which are inconsistent with salary-based tests, such as the deduction from pay, are made in circumstances indicating there was no intention to pay the employee on a salary basis, the exemption from the law is not applicable to him during the entire period where such deductions were made. Conversely, where a deduction is not permitted by the test, it is inadvertent or for other reasons made for lack of work, the exemption will not be considered to have been lost if the employer reimburses the employee for such deduction and promises to comply in the future. Yeah, yeah, Higgins. I feel about the same way as you. I apparently have to give myself an F on my essay question to this question because apparently I came up with the wrong answer. So apparently I'm getting a failing grade in this class. I get an F because I'm nowhere near the right answer. Apparently. You and me both, baby. We both have failed. We didn't get it. Oh, man. Petitioners contend the initial condition in the latter provision, which enables the employee to take corrective action, is not satisfied here because the deduction from the pay was not inadvertent. That it was not inadvertent is true enough, but the plain language of the regulation set out inadvertence and made for reasons other than lack of work as alternative grounds to permitting corrective action. Petitioners also contend that the corrective provision is unavailable to respondents because Guzzi has yet to be reimbursed for his residency-based deduction. In petitioners' view, reimbursement must be made immediately upon discovery an improper deduction was made. The language of the regulation, however, does not address the timing of the reimbursement, and the Secretary's amicus informs us that he does not interpret it to require immediate payment. Respondents are entitled to preserve Guzzi's exempt status by complying with the corrective position. So give him his money back, and we can all pretend it didn't happen. Yay. Yeah. Petitioners have argued finally that respondents failed to carry their affirmative burden of establishing petitioners' exempt status even under the Secretary's interpretation of the salary-based test. Since, however, that argument was inadequately preserved in prior proceedings, we will not consider it here. Okay, guys, remember what I said earlier? Remember what I said earlier about how, like, when things are not, like, brought up earlier, you lose it? Remember when I said that? Remember when I said that, like, normally in normal, like, thinking world, that normally if you're, like, mentioning for the first time in the Supreme Court brief, it's not going to work because you didn't mention it below, and so you've lost it. So the Supreme Court actually agrees with me. Okay, the Supreme Court actually agrees with me because that's what that sentence just says. That's what that sentence says right there. It says, since, however, the argument was inadequately preserved, we will not consider it. That's what I said earlier. That's what I said. That's the same thing. But earlier, they said it's totally cool when the Secretary does it in the brief for the first time. That's not post hoc. That's not lost it. That's not retroactive. That is a good faith interpretation of the statute. I've stopped working, by the way. That's what's happening right now. I'm just going to sit here for a bit. Okay. Okay. So, does everyone sufficiently understand why I don't like Auer now? Does everyone sufficiently understand why I have problems with Auer? Does everyone get it? Does everyone understand the problem? Are we all on board with why Auer sucks? Okay. Let's move on to Brand X. Let's move on to Brand X. The full name of this case is National Cable and Telecommunication Association versus Brand X Internet Services. And it just is, everyone I've ever heard refer to it says Brand X. Normally, like, you would refer to it by the plaintiff's name or the first person's name. So you say, like, National Cable. But, like, everyone I've ever heard has always described it as Brand X. So it's Brand X. It's National Cable and Telecommunication Association versus Brand X Internet Services from 2005. Let me read the facts of the case and the question, not that it matters. This is 6-3, where Scalia was actually in dissent with Ginsburg and Souter. That's a little bit strange. All right, facts of the case. Title II of the Communication Act of 1934, which was amended in 1996, subjected providers of telecommunication services to mandatory common carrier regulations. This should sound vaguely familiar from recent history, too. The FCC concluded that this did not include broadband companies. The Ninth Circuit reversed and cited its own previous opinion that held that cable modem services was a telecommunication service. All right? So we've gone through this issue recently about whether or not internet providers are under Title II or not, right? So, anyways. The question: did the FCC lawfully interpret the Communications Act of 1934 by deciding that broadband cable companies did not provide telecommunication services? Okay. Let's listen to some oral argument, and hopefully this guy will be less annoying. And I'm rapidly running out of my drink, so that's making me sad. My 4 ounces of liquor is not enough. By the way, if you have not already done so, if you'd be so kind as to give the channel a like, and if you're enjoying my suffering, if you would reward me with a super chat, it would, of course, as always, be appreciated. So we're going to listen to this oral argument from this case, and I don't know, see what happened, I guess. Let's get started. Could the Attorney General be considered an agency? Sure, he runs the Department of Justice. Of course the Attorney General is an agency. He runs the agency of the Department of Justice. What are you talking about? It's not even close. Of course he's an agency. Yeah.
Submitted. We'll hear argument next. Number 04277. National Cable and Telecommunications Association versus Brand X Internet Service. Mr. Hunger.
Thank you, Mr. Chief Justice, and may it please the Court. In the Telecommunications Act of 1996, Congress declared that it is the policy of the United States to preserve the vibrant and competitive free market that presently exists for the Internet, unfettered by federal or state regulation. The FCC implemented that clear policy directive in the order under review by concluding that cable modem service should be classified as an information service and not a telecommunications service under the Communications Act. That reasonable determination should be upheld because it is consistent with the text, history, and purposes of the Act. The Act defines telecommunications as the transmission of information without change in form or substance, and telecommunications service as the offering of telecommunications directly to the public for a fee. Given that focus on the nature of the offering to the public, the FCC reasonably concluded that the integrated cable modem service offering should be viewed as a whole in determining its classification under the Act.
Why is that reasonable? I mean, why is it offered to the public if it's offered alone, but it's not offered to the public if it's offered with a tie-in? I mean, if I say, I'm selling you a windshield alone, I guess I'm offering a windshield. But if I say, you got to buy the windshield with a car, am I any less selling you a windshield?
Well, I don't think we would say in that example that you are offering windshields for sale. I mean, to give an example, CarMax.com offers cars for sale over the Internet, but I don't think we would ordinarily say that they're offering windshields or steering wheels or tires for sale. Certainly that's not the necessary construction of a regulatory regime that, say, is designed to focus on sellers of tires. It wouldn't automatically, as a matter of law, have to be applied to entities that are selling cars instead, and the same is true here.
If I just tie it in with windshield wipers.
Well, again,
you can only buy my windshield if you buy the windshield wipers with it. Am I no longer selling a windshield because I'm selling it only with windshield wipers?
Well, I think it would depend on the nature of the regulatory
50-50.
regime.
But don't you think that the telecommunications aspect of what's going on here is at least as important as the information aspect of it? The information is useless unless it can be conveyed.
Well, and by the same token, the transmission component is useless unless it offers all of the information services type functionality that Internet service offers.
Not necessarily. You can use that broadband service to go to other information providers.
But, Your Honor,
I don't really understand the example that they used. I mean, personally, if you're asking me, I wouldn't say if you're selling a car that you're selling a windshield. I also wouldn't say if you're selling windshield wipers and throwing in a windshield, you're selling windshields. So I don't understand this hypothetical. I don't know what's going on. Let's carry on.
It's the capabilities that you purchase in the integrated package, not the pure transmission, but the other capabilities, the computer data processing, data access capabilities that are an essential part of that. If all you had was the transmission with none of the other computer functionality, if you typed in the Supreme Court's website, for instance, supremecourtus.gov, nothing would happen because all of the computer functionality, like the domain name system, which is a very sophisticated, complex.
I will do, Jan. I will do, and thank you for the super chat. Jan says, read the dissent if you run out of your beverage. Yeah, I think we'll probably read the whole thing, including the dissent, because it'll make me feel marginally better. So yeah, I think that's probably a likely outcome. So stay tuned. We will read the whole thing and read the opinion and read the dissent and see if the dissent makes any sense. It's interesting because slightly because for all my hatred of Chevron and Auer and Brand X, I've never listened to the oral arguments before because why would I really, right? I've read the cases before, but I've never listened to the oral arguments before. So you and I are sharing this experience for the first time together. We're listening to the oral arguments. Now, at least in the first two oral arguments, we realized nothing they were arguing about matters. So I guess I didn't miss much before. They're like, oh, what we're talking about doesn't matter. So okay, well, yeah.
Distributed database involving literally.
And thank you, Trent Dow, for the $2 contribution to the beer budget. Trent and Jan, you are both scholars and gentlemen, and you are the best contributors in the channel. And if anyone wants to be a better contributor in the channel, it's open. But for the moment, you guys are truly without equal.
Millions of computers around the world. That's data processing. That's information services capability that you use every time you type in a website. It's not just transmission. It's much more than that. And without the computer data processing aspects, it doesn't do anything.
I agree, but the question isn't whether it doesn't do anything. The question is whether you are still offering telecommunication services to the public. And it seems to me, look, I offer you broadband initially without any information function at the end of it. And you're using this broadband to do all sorts of good stuff, going where you want, getting what you want, conveying what you want. And then I change my rules and I say, in the future, the only way I'm offering this broadband is if you, in addition to buying the broadband communications capacity, buy my information technology at the end of it. Have I suddenly stopped selling the broadband or offering the broadband to the public? I just don't think that's a reasonable use of language.
Well, two points. Your question starts with, I think, an incorrect assumption about the nature of the world. The pure transmission function has not been offered to the public, to consumers, separately. And again, it doesn't do anything. Consumers don't use the pure transmission function by itself. Internet service, by definition, includes the data processing aspects that the Commission so found on this record, and that factual determination is reasonable and supported by the record.
I was giving you a hypothetical.
Well, in the hypothetical, it's conceivable that a different result might be reached by the regulatory agency with authority for construing the statute and applying it to particular fact situations. But I don't think the word offering necessarily and always compels the conclusion that any component of an integrated offering is also separately being offered within the meaning of the statute. It depends on the purposes of the statute as construed by the regulatory agency. Offering is ambiguous, and therefore what the agency has done here is reasonable. And it's supported, I would add, by the consistent pre-1996 regulatory approach in this area, which all parties agreed Congress incorporated into the 1996 Act.
But if you do the same combination over telephone lines, you say they are selling
Your Honor,
to the public communication service.
That's because the telephone companies have always offered a standalone transmission component which other ISPs can utilize. They've done that because of the pre-existing regulatory regime. They've always made the separate offering, therefore it is a telecommunications service.
What bearing does history have upon the definitional question of whether, when you sell a bundled offering of information technology and communications, you are selling communications? With respect to the telephone long lines, you say, yes, you are. And with respect to cable, you say, no, you aren't.
Your Honor, it's certainly not unusual for this Court, in construing a statute, to look to the regulatory history that led up to the enactment of the statute, particularly where it's clear in the legislative history that Congress was essentially borrowing from the pre-1996 regulatory definitions, the definitional scheme that the Commission adopted in 1980 in its Computer II report. All parties agree that that definitional framework forms the foundation for the very definitions at issue here. That's undisputed.
Mr. Hunger, what is the tentative position the FCC has taken on the DSL regulation?
Your Honor, the FCC has tentatively concluded that when a telephone company makes an integrated offering of the DSL transmission capacity with the Internet service as a combined offering to consumers, that tentatively that is an information service, precisely the classification that
even though telephone lines have always been subject to common carrier regulation.
That's correct. And even though when a telephone company is making a separate standalone offering of just the pure DSL transmission capacity, which is useful only to ISPs, to Internet service providers, not to consumers, that would be viewed, has traditionally been viewed as a common carriage offering because it's pure transmission. But when it's
I feel at this point we're learning more law from Phoenix Wright.
a bundled, or when it's an integrated offering, again, this goes back to 1980. This very issue, Justice Scalia, was addressed by the Commission in 1980, and it said if the offering is limited to pure transmission, it is basic telecommunications, basic service, the precursor to telecommunications service. But if you add any computer functionality to the offering, then it is not basic, it is enhanced service. They said that at paragraphs 93 to 97 of the Computer II order.
I understand what they're saying, but they're doing it all on policy grounds. This definition means this because that produces a good result. With respect to telephone lines, they say, yes, bundled is or it isn't, depending upon whether we like the result it produces.
No, Your Honor. It depends on the nature of the offering. If the entity is offering, if cable companies tomorrow start offering pure cable transmission on non-discriminate basis, that would be regulated as a telecommunications service. But what the Commission has always said is that you look at the offering as a whole, and if it's an integrated offering that encompasses not just telecommunications but data processing, computer-type services as well, it's in the enhanced or information service category. The Commission said in 1980, we're doing this in part because it's not clear. It's clear that Congress didn't intend in the 1934 Act to extend regulation to this novel new type of intermingled service. And it would be inappropriate, we think, to try and extend the Act to that for a number of reasons, including that it's very hard to draw lines between which has more of a communications versus data processing component. They had tried that and concluded it was unworkable. And so they drew the line, basic transmission, pure transmission. If the offering is limited to that, it is on the telecommunications service or basic service line. If it contains the computer processing capabilities, data acquisition and retrieval and the like.
But it seems to be saying because the...
Does the rule apply to people that we're listening to? I'm going to say no for the moment, subject to change, but no for the moment. You have my blessing to insult the person that you're listening to. And this case is in 2005, so I don't know why someone mentioned 1980, but this is 2005, so we had a pretty decent idea what the internet was going to be in 2005. I mean, not completely, but, you know, it was around, so.
Cable companies do not offer separate telecommunications service. They don't have to offer it.
Correct.
I mean, it's almost question begging. It's peculiar.
I don't think so, Your Honor. It's only question begging because the respondents have attempted to mischaracterize or misdescribe what is going on here. The rule is, if you are a common carrier, as the telephone companies are, and in 1980, the FCC was regulating in an environment when there was only one avenue into the home, one communications avenue, the telephone line. And they said, under these circumstances, telephone common carriers are not going to be allowed to escape Title II regulation completely by offering enhanced services. If they can offer an enhanced service, an intermingled, integrated transmission and computer data processing service, and that service as a whole, when it's offered, will be unregulated because Title II does not extend to those types of integrated service offerings. They said, however, if it is a telephone common carrier that's making that offering, a facilities-based, typically monopoly common carrier, they will have an obligation to also make a standalone offering of transmission under Title II because they were traditional telephone common carriers. Cable companies are not in that category. They have not traditionally been.
You say that the FCC is changing its view. It has tentatively changed its view, so it will bracket the telephone companies with the cable companies.
Well, actually, that's an important point, Justice Ginsburg. The FCC has never said that an integrated offering of DSL internet service, the combined integrated offering, the analog to what we have here in the cable context, the FCC has never said that is not an information service. They have tentatively concluded now that it is. What they said in the 1998 order that respondents cite was that the telephone companies are already offering DSL on a standalone, pure transmission basis to other competing internet service providers. Therefore, it is a telecommunications service. Indeed, it was undisputed that it was a telecommunications service. And again, the reason they were doing that, we assume, is because the pre-existing Computer 2 and Computer 3 framework required the telephone carriers to make that standalone offering. But the Commission has not said the integrated offering is also a telecommunications service, and it has now tentatively concluded that it's an information service in keeping with 25 years of regulatory history.
What would be left in the common carrier category?
Well, any standalone pure transmission offering, including under the Computer 2 rationale to the extent that the Commission adheres to it, and it hasn't overturned it yet. It's considering the extent to which it should create an exception in the DSL context. But under Computer 2, a basic traditional common carrier cannot get out of Title II regulation by offering an integrated offering. They will also have to make the standalone offering unless, and to the extent the Commission determines that that's not necessary, for instance, because the enhanced or integrated information service market is sufficiently competitive that it's not necessary and there are adequate alternative communications pipelines.
wonderful policy, but I don't what I'm still waiting to hear is how you get that out of the definitions, which is the lever that the Commission is using to implement this good policy. It is saying in some cases.
Well, finally, Justice Scalia is asking what I consider to be the right question, you know. As it will come surprise to no one, I tend to align with Justice Scalia pretty well. And so Justice Scalia is asking what I consider to be the right question. How do you get it out of the definitions? Right? This policy sounds fantastic. It's the greatest policy ever. Where's your authority for it, though? How are you getting out of the definitions you have to work with? Right? This is the question I want to know. It's like, where are you getting this from? So, yeah. Microtrenching has backfired quite badly. I don't know anything about that or the reliability trouble. Tell me more. Let's press on. Trent, tell me more. Give me a link to what you're talking about. I'd appreciate it.
That a bundled offering is an offering of telecommunications, and in other cases it's saying a bundled offering isn't. And the reason you say is not because of the nature of the thing, because of the definition. It's because you tell us it has good consequences in one case and doesn't have good consequences in the other. But
Your Honor, I'm sorry, but
not my understanding of how definitions work.
Let me try to clarify what the Commission's position is. The Commission has never said, that I am aware of, or that respondents have pointed out, that the integrated, bundled, if you will, the integrated offering of transmission plus Internet service functionality is a telecommunications service. They have never said that. They have said that some companies, telephone common carriers, will be required to make the separate offering, but it is not correct that the integrated offering is itself going to be classified as a telecommunications service.
So it's in effect, it's the unbundling requirement, which is your answer to Justice Scalia's. Why should that make a difference? I mean, it could just as well make an unbundling requirement with respect to cable.
You could. And in fact, the Commission has issued a notice of proposed rulemaking or an invitation for comment in the order under review here to consider whether it should make such a requirement under its ancillary Title I authority in this context, and if so, to what extent.
And the reason for a distinction, at least at the present time, the reason for the reasonableness of a distinction at the present time as a source of applying this definition is history, basically.
History, and not unrelated to that, the fact that the cable companies have not traditionally been regulated as common carriers under Title II of the Act. Yes, that's correct. And then just one final point, if I may, and Justice Scalia, I think this also goes to your question. Respondents are the ones who are being inconsistent, and the states, for instance, they suggest that they say, cable modem service should be regulated as a telecommunications service in part, but of course, traditional information service providers, ISPs, should not be their pure information service, even though ISPs also provide transmission. They provide telecommunications. Information service Internet service does not work unless you have transmission from wherever the telephone call goes into the central office, and it has to be transmitted from there to the Internet service provider's point of presence on the Internet, and from there out onto the Internet. And Internet service providers either own or lease that transmission capacity and offer that as part of the bundled offering that they make. So every Internet service provider would be a telecommunications carrier under their position, and that is contrary to what the FCC said before the 96 Act, and it's contrary to what Congress said in the 1996 Act.
They claim that that's by toleration of the FCC. I was going to ask them about that. Don't worry.
Thank you. If I may reserve the balance of my time.
Very well, Mr. Hunger. Mr. Capuccio, we'll hear from you.
Thank you, Mr. Chief Justice, and may it please the Court. Let me begin by trying to answer Justice Scalia's question. The question here, Justice, is are we offering two products, or are we offering two ingredients that come together to form a separate product? And I would submit that if you go back and read paragraph 120 of the Computer II order in 1980, that's exactly what Congress said was happening. What Congress said is when you take, not Congress, I'm sorry, the FCC, of course, when you take the communications component and the data processing component and combine them, they are ingredients into what is a new offering. and a new and unregulated offering. They've said we can't separate them. It's not useful to try to separate them, and we view them as two ingredients forming a product that is a distinct product.
What is the data processing part?
In the case of cable modem service, Your Honor, it's a number of things. It's the ability to, for example, retrieve information from a server that somebody has on the web.
So I guess on that one, if in fact you had a telephone system and at the other end of the wire, Joe Smith, your friend, had recorded a message, and when you rang the call, the service simply picked up the message and played it to you, wouldn't it still be a telephone system?
Well, I think in your situation, in the hypothetical you give, Your Honor, that would be somebody using just a regular transmission-only path to hear what the other person.
And how is this different?
Well, because here, in the example that I use, for example, it's certainly not the only one, it is the capacity to retrieve information that is stored otherwise, and that falls, Your Honor.
Information that other people have stored otherwise?
Yes, and not necessarily.
Well, why isn't that even more telecommunications than my answering service?
Well,
I pick up my messages.
I would say, Your Honor, for one thing, it fits squarely within the definition of information service, which says.
Well, yes, of course it does, and so does my answering service.
Well,
all right. What about the next one? What I want to do is write down a list of those things that are not telecommunications.
It's the ability to engage in to use your email. It's the ability.
The ability to engage or use my email is an ability to access messages that other people who don't work for you have left for me. Now, again, I keep thinking of my answering machine.
Right.
And it doesn't seem very different. Right. But anyway, what's the third?
Well, it's anything that allows you to browse the world.
I'm sad because I ran out of liquor and Justice Breyer is asking questions now.
Okay. Wide web, and to retrieve information from the World Wide Web.
Yes, indeed.
Right.
What it is a system where I pick up the phone, and what my phone does is, let's say it had the ability to survey a number of possible people who wanted to talk to me. Would that suddenly change it from a phone to a computer or an information system? Because the other people are leaving the information. It's not the phone that's doing it.
Your Honor, the ability to retrieve information that is stored somewhere out on a server is not a raw transmission functionality. It is more than that. It is what it said, what the Congress has said it is. It is the ability to retrieve information. It is not simply sending bits over a line and having those bits not change and not interfered with. When you retrieve something from a server, you have to take it in the form it is on the server. You have to then put it through the transmission system, and you have to reconvert it back into what you want to see. It's an interactive process that is more than just sending information.
Rather like when I phone Europe, and they take the message and turn it into electronic packets, and they send it all over the world and on computers and so forth, and it comes back to me eventually. Sounds a lot like my brother-in-law.
Yeah, I guess, look, Your Honor, I am not disputing that an information service has a component of it that's communications. It may indeed have a component of it that's communications. But what the FCC said in Computer 2 is that when you combine the communications with, for example, the data retrieval function, that combination of things is no longer the two separate products. It is a new enhanced service that is beyond Title II. And Justice Scalia, part of the evidence that these are not two separate products is if they were, then Congress never could have said that enhanced services were outside of Title II. Computer 2 would have to be wrong and overruled, even though it's now 20.
The FCC.
I'm sorry, I keep saying Congress meant the FCC. The FCC could not have said that because it would have been forced if as the theory goes, the enhanced.
I do like that slip up. I do like that slip up because it goes to like the heart of what I think the problem is, right? He says, yeah, I'm sorry. I keep saying Congress, I mean the FCC. That Freudian slip there kind of reveals the game for me, right? Who gets to write laws? And he kept saying Congress, not the FCC. I find that hilarious. You know, there's some deep part of himself that thinks, hey, Congress did this, right? No. It was the FCC. I know that Schoolhouse Rock song is in your head and you're saying what Schoolhouse Rock song taught you, but it's no longer I'm just a bill. I'm just a regulation to be, and I'm sitting here on the secretary's desk where he signs me into being, and then he reinterprets me as he needs me, because I mean whatever he needs me to mean for liberty.
Service has in it the separate product of communications and has a separate status, then they wouldn't have been able to take it out of computer. But let me suggest, stepping back for a second, and by the way, I should add that in this case, in paragraph 39 of the order under below, the FCC said the two were not separable.
You know, just as an aside, one of the bills Congress posed when they came into session, was it H.R. 1? It was something like that, where they posed to overturn Chevron. Hold on. I have to figure out what happened to that. Was it H.R. 1? Let's see. Well, they passed something in 2016. It's 2019. Hold on, we're taking a brief diversion. I'm looking up what happened to this bill that was proposed to overturn Chevron. Separation of Powers Act? This is 2019. It was introduced, bill number 1927. I could have sworn there was something more, a lower number than that. Well, what happened to HR 1927? It has gone. It's gone nowhere. It's gone absolutely nowhere past introduction. That's frustrating. Yeah. Chevron could overturn. I mean, Congress could overturn Chevron with legislation. It's something Congress can do. It's not a constitutional decision. It's a decision of Congress's intent. All Congress has to do is literally write a bill that says Chevron, Auer, and Brand X are hereby overturned, and any interpretation of any statute and or regulation shall be vested in the judiciary, who shall review any legal question de novo with respect to any interpretation from the executive branch. They could do that. I really wish they would do that. That'd be great. But no, here we are. Okay.
Okay, I understand that to mean they are ingredients intertwined. They are not separate products. But the basic thing that the agency did here, which is decide which of two things is happening. Are these two separate products? Is this communications and chicken McNuggets being bundled together? Or are these two ingredients that are so interwoven, as they said in Computer 2, as to form a distinct product, is a classic example of what an agency does. And it's really not one that this court...
So I suppose a lot of this is Congress's fault, as it always is. Right? If Congress is the one that gets to pass laws and these decisions are wrong, Congress can fix it. All Congress has to do is pass a different law. They can do it as a single law. They can do it in 2 sentences. I gave you a draft. Stick it in the judiciary jurisdiction section somewhere, which I think is in Title 28. So just put in the section dealing with the power of the judiciary. Stick it in there as a new subsection somewhere. Yeah, you could do it. You could do it in 2 or 3 lines, I'm sure. Insert it as a new subparagraph somewhere. So I suppose a lot of this is on Congress. So Congress must want it this way. Yay.
I think would be likely to second guess. It is indeed, in fact.
I think the difficulty that we're having is that it says it in the cable context and it doesn't say it in the wire context. And you can say it just as intelligibly in the wire context. Yeah. It's just that you haven't been saying it.
Let me try to clarify that, Justice Souter. The reason why DSL meets the definition of telecommunications service and we don't is because the telephone companies do, in fact, provide the transmission-only component. Now, the reason they do that, Justice Souter, is, as Mr. Hungar said, historical, though it wasn't without basis in reasons in history. But they do, in fact, provide it separately. They do because Congress required them to do it through a separate subsidiary in Computer 2. There were reasons for that. They wanted to avoid cross-subsidies. They were the only platform they were worried about discriminations.
So is that really the nub of the difference? It's Congress that is requiring them to do it separately, and Congress doesn't have a comparable requirement with respect to cable. I
read the statute this way. Congress takes the world as it comes. If you are providing it as a common carrier, then you fall within, you're providing it separately, then you fall within the definition of telecommunications service. The DSL guys are. If you are not, and we are not, then you don't fall within
but that begs the question.
Your Honor, I beg to differ that it begs the question. It just says that it's for someone else to decide the second prong of the Nehru test, which is, should you be compelled? Okay? The Congress doesn't decide that. It's crazy to think that Congress decided forever and ever and ever that everybody who came in would be a common carrier no matter what the market looked like. Congress instead took the world as it came, and it relies on the FCC, and there are perfectly fine reasons for that. The reasons that pushed them to do it in 1980 to the telephone companies about cross-subsidies have no application to us, and the discrimination justifications back then.
Basically, you're saying interstitial lawmaking, like other kinds of lawmaking, can be reasonable without being absolutely consistent at a given moment.
Correct, Your Honor.
Yeah.
Thank you.
That still doesn't explain. It still doesn't explain, to my satisfaction, why it becomes a different product.
Okay, let me try.
A different product when you're selling it separately, and it is not a different product when you're not selling it separately.
Because, Your Honor, it's whether the words offering telecommunications are ambiguous. If I bake cakes and someone was to say, if you offer cakes, you don't offer butter, there's nothing in the English language, Justice Scalia, that makes that unreasonable. That a person who offers cakes to the public does not offer butter to the public. And if you believe that example is correct, then you have to uphold the FCC, because what it says is the offer of the final product is not offering to the public the ingredient.
Unless you also sell butter.
Separately.
If you sell butter separately, then when you sell a cake, you're selling butter.
The ILEX do, we don't.
Thank you, Mr. Capuccio. Mr. Goldstein, we'll hear from you.
Nice one.
Thank you, Mr.
Nice
Chief
comment
Justice,
about Mira. That's a good one.
The court will want to have handy, I think, the red brief of the respondent's Earthlink et al., because I will repeatedly take you to the text of the statute, which is reproduced at the appendix to that brief. Mr. Chief Justice, cable modem service refers to the bundled sale, purely for marketing reasons, of two different things: high-speed telecommunications over cable wires and computer software like email that you can access over that high-speed telecommunications. The Commission admits, and it is a critical admission, that the standalone sale of the telecommunications piece is a telecommunications service, notwithstanding that it is on cable wires rather than telephone wires. The Ninth Circuit correctly held that it makes no difference that cable companies market the telecommunications with email and the like. Congress cannot have intended to empower carriers to deregulate themselves through the nicety of adding some further feature to their common carriage. And I think we can demonstrate that through the text of the statute. I'd like to take you to two provisions at the outset. The first one is on 2A of the appendix, and it goes, Justice Souter, to the question of whether there's some difference that Congress has adopted between telephone wires and cable wires. And the answer to that question is no. Subparagraph 46, the definition of telecommunications service, this is the provision that leads to common carrier regulation. The term telecommunications service means the offering of telecommunications for a fee directly to the public or to such classes of users as to be effectively available directly to the public, and here's the critical clause, regardless of the facilities used. Congress made quite clear it was not drawing any distinction based on cable wire versus telephone. I'd like to point you to two other provisions. They're not reproduced because they're in the separate cable provisions, but they will be relevant to your question. That is 47 U.S.C., 541D, and 522. Those specifically contemplate that cable companies will be common carriers. Now, that's the answer to the question, is there a difference between a cable wire and a telephone wire? Let me now step back to what the FCC said in its ruling. The FCC backed into its decision here, and it will turn on the definition of information service, which will be on 1A of the appendix. It said this, look, cable modems...
All right. I kept up as long as I could. It was a half hour of oral discussion. We're now moving on to discussion of the case, because that's what everyone came for. Because, right, do we really care that much about whether it's, common carrier or not? Well, I don't. So we're not doing that anymore. So, there. Let me find a PDF that has the entire thing in one big ass PDF so I don't have to keep scrolling around. Hold on. Just want a PDF, man. Just want the PDF. Please give me the PDF. I don't want 4 separate PDF versions. I want one PDF version. I want the decision that it was issued from the Supreme Court as one decision. I just want the one decision. Does Wikipedia have it? I just want the PDF the Supreme Court actually issued. Why can't I get this? Why is this so hard? I just want the decision. I want the decision. I want all of it. I don't want a brief. I want the decision. I just want the decision. I don't want your brief. I want the decision. Please give me the decision. All right, this will do. This will do. We'll have to go between different PDFs, but this will do. All right, this will work. Let's scroll past the introduction. Oh, is there not a summary? Doesn't look like there's a summary. Usually there's a summary at the top. Okay, well, never mind. All right, let's start with Justice Thomas. Justice Thomas wrote the opinion of the court. Justice Thomas, who's like the most conservative person ever. Right now I'm using Firefox and Chrome. So I'm kind of flipping between them, in case you care. Oh, man. Mozilla great. Firefox is great because Mozilla pays you. Well, yeah. Thomas wrote the opinion of the court. Justice Thomas wrote the opinion of the court. Great. So that's great. Title II of the Communications Act as amended subjects all providers of telecommunication services to mandatory common carrier regulation. In the order under review, the FCC concluded that cable companies that sell broadband internet services do not provide telecommunication services as exempt from mandatory common carrier regulations. And then they would say later that they did, and then they say even later that they didn't. So that's where we are. Yes, anything can be great if you get paid enough, and at this point, I'd once again like to tell everyone about the miracle that is Raid Shadow Legends. We must decide whether that conclusion is under a lawful construction of the Communication Act under Chevron and under the Administrative Procedure Act. We hold it is. Of course you do. The traditional means by which consumers in the United States access networks of interconnected computers that make up the internet is through dial-up connections over local phone facilities. So this was written a little bit ago. Using these connections, consumers access the internet by making calls with their computer modems through telephone wires owned by local phone companies. Internet service providers in turn link those calls to the internet network, not only by providing a physical connection, but also by offering consumers the ability to translate raw internet data into information they may view on their personal computers and transmit to other computers connected to the internet. Technological limitations of telephone wires, however, retard the speed at which the data from the internet may be transmitted to end-user dial-up connections. Dial-up connections are therefore known as narrowband or slower speed connections. Broadband internet services, by contrast, transmit data at much higher speeds. There are two principal kinds of broadband internet service providers: cable modem and DSL. Jan, I don't know if the biggest problem is the court doesn't want to destroy precedent. I want to destroy precedent. Put me on the Supreme Court. I'll do it. I'm ready to go. I'm ready to destroy precedent. Let's do it. Cable modems, I mean, I don't say that lightly, Jan. I don't think precedent should be just flippantly ignored. So I think precedent has value and certainty has value, but I've given this quite a bit of consideration. And I just think that they're wrong and should be reversed, and they were bad to start with. And if they weren't bad when they were decided, they've grown into this massive thing. So change in circumstances is as good a reason as any to overthrow them. So Kurt Mueller for Supreme Court. He'll overrule Chevron and Auer and Brand X and start, actually making Congress actually pass laws. Yeah. Matthew says you don't see how you can ignore people writing the laws, but listen to 100% who people apply the law. I tend to agree with you, Matthew. I think we should ignore them both. I think the judiciary gets to decide what the law means. That's what I think. And Congress gets to write laws and the executive gets to enforce laws. So if there's a question as to what the law means, ask me. I'll tell you what it means. And if you don't like that answer, then go back and get a different law passed. As I said, I'm not God. I'm just trying to do the best I can over here as a judge. So, if I get it wrong, that's fine. I promise I won't take it personally. No problem. DSL service providers provide high-speed access using local telephone wires owned by local phone companies. Cable cone and telephone companies can either provide internet access directly to consumers, thus acting as ISPs themselves, or they can leave transmission facilities to independent ISPs and use the facilities to provide consumers with access. Other ways of transmitting high-speed internet data into homes include terrestrial and satellite-based wireless networks are also emerging. At issue in these cases is the proper regulatory classification under the Communications Act of broadband cable internet service. The Act, as amended by the Telecommunications Act of 1996, defines two categories of regulated entities relevant to these cases: telecommunication carriers and information service providers. The Act regulates telecommunication carriers but not information service providers as common carriers. That's the difference between Title I and Title II of the Act. So Title II carries the telecommunication service, and Title I carries the information providers, and one is subject to different answers than the other. So that's where we are. Telecommunication carriers, for example, must charge just and reasonable non-discriminatory rates, design their systems so other carriers can interconnect, and contribute to the Federal Universal Service Fund. So that's what we would call common carriers. Title II are common carrier. Title I is not. And at the moment, under the current regulations, they are not common carriers because the Trump administration changed that, which came up with its own set of downsides, but that's where we are. So if they're regulated under Title II, they are common carriers. If they're regulated under Title I, they're not. So that's, the distinction. These provisions are mandatory, but the Commission must forbear from applying them if it determines the public interest requires it. Information service providers, by contrast, are not subject to mandatory common carrier regulation, though the Commission has jurisdiction to impose additional regulatory obligations under Title I. Jurisdiction to regulate interstate and foreign communications. The two statutory classifications originated in the 70s as the Commission developed rules to regulate data processing services offered over telephone wires. That regime, the Computer 2 rules, distinguished between basic services like telephone services and enhanced services offered over telephone lines. The Computer 2 rules define both basic and enhanced services by reference to how the consumer perceives the service being offered. In particular, the Commission defines basic service as a pure transmission capability over a communications path that's virtually transparent in terms of intersection with customer-supplied information. By pure or transmission, the Commission meant a communication path that enabled the consumer to transmit ordinary language message to another point with no computer processing or storage of the information other than the processing or storage need to convert the message into electronic form and then back into ordinary language for the purpose of transmitting it. Basic service was subject to common carrier. Enhanced service, however, was service in which the computer processing application were used to act on the content, code, protocol, and other aspects of the subscriber information, such as voice and data storage, as well as protocol conversion. By contrast to basic service, the Commission decided not to subject providers of enhanced service, even enhanced services over transmission wires, to Title II. The Commission explained that it was unwise to subject enhanced providers to common carrier regulations given the fast-moving competitive market in which they were offered. Okay. The definition of the terms telecommunications service and information service established by the 1996 Act are similar to Computer 2 basic and enhanced service. Telecommunication service, the analog to basic service, is offering the telecommunication for a fee directly to the public regardless of facilities used. Telecommunication is transmission between or amongst points specified by the user of information the user is choosing without changing the form or content of the information as sent and received. Telecommunication carriers are thus subject to mandatory Title II. All right, let's skip ahead a little bit because they're just talking about rulemaking stuff. So let's skip a little bit. Talking about the integration, skip. Same reasoning, skip. Okay. We first consider whether to apply Chevron framework to the communications interpretation of the term telecommunications service. We conclude that we should. We also conclude the Court of Appeals should have done the same instead of following the contrary construction it adopted in Portland. Okay, now we're going to talk about Chevron a little bit. The court held that ambiguities in statutes are to be administered and delegated to the authority of the agency. Yay. Yeah, I'm with you. I'm with you, Jan. Thomas was not my favorite writer. He wrote some good ones, but yeah. Chevron. Oh, this is good. Some of the respondents disagree with the conclusion on the ground that the Commission's interpretation is inconsistent with its past practice. We reject this argument. Agency inconsistency is not a basis for a decline to analyze the interpretation under the Chevron framework. Unexplained inconsistency, as at most, a reason for holding an interpretation to be arbitrary and capricious change under the Administrative Procedures Act. For an agency to adequately explain the reasons for reversal, change is not invalidating, since the whole point of Chevron is to leave the discretion provided by the ambiguities of statute with the implementing agency. So, see, we're getting into the bad part of the decision, right? Reversals are no problem. Because it's to the agency. So change is invalidating. That's the whole point of Chevron, to give them flexibility to completely change what a statute means and the regulations mean on the fly. Right? That's what we just read, right? For the agency adequately explains the reason for reversal, change is not invalidating, since the whole point of Chevron is to leave discretion provided by the ambiguities with the implementing agency. That's Brand X, right? That's the heart of Brand X. The agencies get to change their mind. It's not a problem. Right? An agency's interpretation is not carved in stone. On the contrary, an agency must consider varying interpretation the wisdom of policy on a continuing basis. So Congress, when it writes laws, means exactly what they meant when they wrote it, and it doesn't change. But agencies do change. So agencies are more powerful than Congress. Okay. The Court of Appeals declined to apply Chevron because it thought the Commission's interpretation of the Act foreclosed by the conflicting construction of the Act it had adopted. So it's saying you can't do this because of the conflict. It's saying you can't adopt this interpretation because you previously adopted this interpretation, and they can't possibly both be right. That was the Court of Appeals. All right? The base is holding on the assumption that Portland's construction overrode the Commission regardless of whether blah, blah, blah. That reasoning is incorrect. That's Brand X. So just because you said one thing one day and another thing another day, that's not a problem, even if they flatly contradict. That reasoning is incorrect. The same exact language can mean two completely polar opposite things at the exact same time. It's Schrodinger's law of statutory interpretation or something. Hey, Higgins, this was someone else's idea. You guys have been kind of pinging me for a while to cover these cases. Like, why not Chevron? Why not Chevron? Talk about Chevron. Well, we're covering it now. We covered Chevron, now we're covering Auer and Brand X. Okay? This is your guys' fault. I blame you. A court's prior judicial construction. Okay. So, all right, this is good, guys. All right. So this is good. I want you to pay attention to this part, okay? All right. So let's suppose this is what you're about to hear, and I want to explain it in advance, okay? Suppose a agency says the interpretation of the law is something. Then a court of appeals says the law is that thing. Now the agency changes its mind. But wait, there's a court decision that says the interpretation of this regulation means this. So who gets to decide if the change is okay? Do you have to go get an en banc from the Court of Appeals to overrule their prior judicial decision, which said the statute/regulation meant this? Or can the agency overrule the Court of Appeals? Okay? That's where we are. Pay attention. We're about to discuss that question. Okay? A court's prior judicial construction of a statute trumps an agency's construction, otherwise entitled to Chevron deference only if the prior court decision holds the construction follows from the unambiguous terms of statute and thus leaves no room for discretion. This principle follows from Chevron itself. Chevron established a presumption that Congress, when it leaves an ambiguity in a statute, meant for it to be implemented by an agency, understood the ambiguity would be resolved first and foremost by the agency, and desired the agency, rather than the courts, to possess whatever degree of discretion the ambiguity allows. Yet, allowing a judicial precedent, I want you to understand this. I want you to listen to it, okay? I want you to listen to it. All right? Yet, allowing a judicial precedent to foreclose an agency from interpreting an ambiguous statute as the Court of Appeals assumed it could would allow the court's interpretation to overrule the agency. Do you fully understand what just happened? Do you fully understand what just happened? The Supreme Court says that a judicial interpretation which said that the regulation means X can be overruled not by an en banc court, not by the Supreme Court, but it can be overruled by the agency. Agency gets to overrule a court. That's what that just said. Yet, allowing a judicial precedent to foreclose an agency from interpreting an ambiguous statute as the Court of Appeals assumed it could would allow the court's interpretation to override an agency's. Thus, the agency must overrule the court. I'm not making this stuff up, guys. I'm not making this stuff up when I tell you that the law is certain things. When I've been ranting and raving that Chevron allows them to, and by Chevron I usually mean the collected cases when I say Chevron, but then when I say that Chevron allows them to reinterpret the rules and statutes and allows them to redo it on the fly and change their mind at any time, I'm not making this stuff up. I am not making this stuff up. It's there in black and white for us all to read. That's what that says. The better rule, the better rule. Please tell me the better rule. The better rule is to hold judicial interpretations contained in precedent to the same demanding Chevron Step 1 standard that applies if the court is reviewing the agency construction on a blank slate. Only judicial precedent holding the statute unambiguously forecloses it, there contains no gap to fill, displaces a conflicting agency construction. Thus, if there's ambiguity, it's not the court who resolves it, it's the agency. The agency has judicial power, and they can overrule themselves. That's Brand X. That's Brand X. I'm not making this stuff up, guys. I'm not making this stuff up. Yeah, this is Justice Thomas who's writing this, which doesn't seem very conservative to me, but when I told you this is what these cases said, I was not making this up. You can read it for yourself, and now I'm reading it with you, and I'm clearly explaining exactly what this means. A contrary rule would produce anomalous results. It would mean that whether an agency's interpretation of an ambiguous statute is entitled to Chevron deference would turn on the order in which the interpretation issued. If the court's construction came first, the construction would prevail, whereas if the agency came first, the agency construction would command deference. Yes, there is a contradiction there. There is a contradiction there. It would produce anomalous results. In my humble opinion, the way to fix the anomaly is by striking down Chevron. Yes, you're right. There's a conflict here. If you did this, then if the agency's first, they win, but if the court is first, they win. That doesn't make sense. So this is the part of the opinion where you're going to say, oh, therefore we should strike down Chevron, right? Right? This is the part where you're going to say we should strike down Chevron, right? Yet, whether Congress has delegated to an agency the authority to interpret statute does not depend on the order in which judicial and administrative constructions occur. The Court of Appeals rule, moreover, will lead to the ossification of large parts of our statutory law, as opposed to like what Congress did. The statutory law is supposed to be ossified. That's kind of the point. It means what it means until Congress means it. Wait, what are we... What is Justice Thomas talking about? What's Justice Thomas talking about? This is like living Constitution. Now they're living statutes. How is Justice Thomas writing this opinion? How is he saying that we have living statutes that change their meaning? This is a liberal thing to say. This is liberal, not conservative. And Justice Thomas is the most conservative person in the history of ever. What the hell happened here? He's saying, I mean, he would agree with me, no problem, that there's no such thing as a living constitution. And now he's saying the statutes are living because it would lead to ossification of the statutory law. Yeah, that's kind of what it's supposed to be. It's supposed to be ossified. It means what it means when Congress wrote it and nothing more. And if Congress wants something else, then change it. This is like this is living statute thing. This is left leaning. This is left leaning judicial ideology. I don't understand it. I don't understand it coming. First of all, I don't understand it myself because I think left leaning ideology is wrong. And second of all, I definitely don't understand it coming from Justice Thomas. What is this? What is this living statute stuff? Because lest we have ossified statutes. I don't understand. I don't understand. I don't get it. I don't understand. It's usually the left. It's usually left-leaning judges who talk about a living constitution and interpreting it as it needs for current times. It's usually conservatives who go the other way. And now Justice Thomas is writing something that sounds like it came out of a left-leaning judicial mouth. I am so confused. I don't understand. The dissent answers that allowing an agency to override what a court believes to be the best interpretation of a statute makes judicial decisions subject to reversal by executive officers. Yeah. It does not. Yeah, it really does. Yes, it really does. Since Chevron teaches a court opinion as to the best reading of an ambiguous statute, an agency is charged with administering is not authoritative. Ooh. Right, let's read that again. Since Chevron teaches that a court's opinion as to the best reading of an ambiguous statute an agency is charged with administering is not authoritative. So the Supreme Court is literally writing that if there's an ambiguous statute and a court has ruled on it, the court's interpretation is not authoritative if an agency administers that statute. Judicial opinions are not authoritative. I don't know what to say. Instead, the agency may, consistent with the court's holding, choose a different construction since the agency remains the authoritative interpreter of the statutes. In all other respects, the court's prior ruling remains binding law, even though it's not authoritative, which is a neat trick. The precedent has not been reversed by the agency any more than a federal court's interpretation of state law can say to be reversed by a state court adopting a conflicting interpretation of state law. Well, there's quite a lot of difference in this jurist's humble opinion if a state legislature is changing the state law and to do so to overrule a judicial decision. Because it's the legislature doing it. That's what legislatures do. They make laws. So if the judiciary fucks it up, the state can change this law. No problem. So I have no problem with Congress or the state legislature overruling judicial decisions. That's kind of what they're supposed to do. If a court screws it up, change the statute. No problem. But an executive branch do it? No. 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 Okay. Let's talk about stare decisis a little bit. As the dissent points out, it's not logically necessary for us to reach the question of whether the Court of Appeals misapplied Chevron for us to decide whether the Commission acted lawfully. Nevertheless, it's no great mystery while we're reaching the point here. There's genuine confusion in the lower courts over the interaction between Chevron doctrine and stare decisis. Yeah. As petitioners informed us at the certiorari stage. And not reaching the point could undermine the purpose of granting cert to settle authoritatively whether the Commission's declaratory ruling is lawful. So this is authoritative, even though like all these other ones aren't authoritative, but this decision is authoritative because we're deciding authoritatively, right? Were we to uphold the declaratory ruling without reaching the Chevron point, the Court of Appeals could once again strike down a Commission rule based on its decision. Portland could compel the Court of Appeals to once again reverse the Commission despite our decision, since our conclusion is that it's reasonable to read the Communication Act to classify cable modem services solely as information services leave untouched. Portland's Holden ruling that the Commission had before it decide similar questions, not strictly speaking necessary. Is prudent for us to reach this question? Great. Now they're discussing the statute and the interpretation, whether it's reasonable, which I don't care because, of course, it is. So I don't care about all this stuff. They're analyzing whether or not it was a reasonable interpretation, but the answer is yes. So why read the analysis? Blah, 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 blah. More reasons the Commission was good. No. In sum, if the Act fails unambiguously to classify non-facility-based information service providers that use telecommunication inputs to provide information service as offerers of telecommunications, it also fails unambiguously to classify facilities-based communication providers as telecommunication services. The relevant deficiencies do not distinguish facilities and non-facility-based carriers. That silence suggests instead the Commission has discretion to fill the gaps. All right, well, that's it. You guys got the gist of why I don't like this opinion, right? You understand, right? I read all the critical sections about how you can overrule stuff and how judicial interpretations are non authoritative and how they can change it. Any reasonable interpretation will do, and so forth and so on. So you guys get the gist. So, yeah. How long is the dissent? 17 pages. Let's read some of this so I can feel marginally better. Justice Scalia, with whom Souter and Ginsburg are writing. All right, Justice Scalia. Make me believe in you. I agree to the court's example that it'd be odd to say a car dealer is in the business of selling steel or carpets because the cars he includes both steel and carpets. Nor does the water company sell hydrogen, nor the pet store water. But what is sometimes true is not, as the court seems to assume, always true. There are instances in which it's ridiculous to deny that one part of a joint offer is being offered merely because it's not being offered on a standalone basis. If I, for example, call up a pizzeria and ask whether they offer delivery, both in the common sense usage would prevent them from answering, no, we do not offer delivery. But if you order a pizza from us, we will bake it for you and then bring it to your house. Yeah, that's a fair point, right? The logical response to this would be something on the order of, so you do offer delivery, but our pizza man may continue to deny the obvious and explain, paraphrasing the FCC and the court. No, even though we bring the pizza to your house, we're not actually offering you the delivery, because the delivery that we provide to our end users is part and parcel of our pizzeria pizza at home service and is integral to its other capabilities. Any reasonable customer would conclude at this point that his interlocutor was either crazy or following some too clever by half legal advice. Do you offer delivery? No, but we'll bring it to your house. So you do offer delivery? No. I like that. That's cute. That's cute. I like that. I like that. It makes me smile. See the smile on my face? I like it. It makes me happy. In short, for the inputs of finished service to qualify as objects of offer, as the term is reasonably understood, is perhaps sufficient, but surely not necessary condition. The seller offers separately each discrete input that is necessary to providing a finished service. The pet store may have a policy of selling puppies only with leashes, but any customer will say that it does offer puppies, because a leashed puppy is still a puppy, even though it's not offered on a standalone basis. Despite the court's mighty labors to prove otherwise, this is like some good Scalia right here. I feel the Scalia. I wish I was this good. I wish I was this good that I could write like this, but I am not this good. And neither is anyone else. There is no other Justice Scalia, man. He's one of a kind. No one else can write like this, man. He is so good. He fell off a little bit right at the very end, but this is really good stuff. Because the court made mighty labors to prove otherwise, the telecommunication component of cable modem service retains such ample independent identity that it must be regarded as being on offer, especially when seen from the perspective of the consumer or the end user, which the court purports to find determinative. The commission ruling begins by noting cable modem services provide both high-speed access to the internet and other applications and functionalities because that is exactly how any reasonable consumer would perceive it consisting of two separate things. The consumer view of the matter is best assessed by asking what other products cable modem services substitute for in the marketplace. Broadband internet service provided by cable companies is one of the three most common forms of internet service, the other two being dial-up and DSL. And each of the two, the physical transmission pathway to the internet is sold, indeed legally required to be sold, separately from internet functionality. With dual access, physical pathway comes from telephone company and internet service provider provides the functionality. Since the delivery service provided by the cable is downstream from computer processing facilities, no question it merely serves as conduit for the information services already been assembled by the cable company. This is relevant because statutory distinction between information service and telecommunication. This reveals the insubstantiality of the fear invoked by both the Commission and the Court, the fear of what will happen to ISPs if they do not provide the physical pathway to internet, yet still use telecommunications to acquire the pieces necessary to assemble the information that they pass back to the customer. According to somewhere else in the opinion, if cable modem services providers are deemed to provide telecommunication services, so must all ISPs because they all use telecommunications. In terms of the pizzeria analogy, this is equivalent to saying that if a pizzeria offers delivery, all restaurants offer delivery. That's nice. Because the ingredients of the food they serve the customers have come from other places, no matter how the customers get the food. They still consume a product for which delivery was a necessary input. This is nonsense. Concluding the delivery of a finished pizza constitutes an offer of delivery does not require the conclusion that serving of prepared food includes an offer of delivery. And since that analogy doesn't even do the point justice, since telecommunications service is defined as offering telecommunications for a fee directly to the public, the ISP's use of telecommunications in their processing of information is not offered directly to the public. And that's a very fair point. You can't process information separately. That doesn't really make sense. So, yeah. The court also puts great stock in its conclusion that cable modem subscribers cannot avoid using information services provided by the cable company in its ISP capacity, even when they only click through to other ISPs. For even if a cable modem subscriber uses email from another ISP, designates some page not provided by the cable company as his homepage, and takes advantage of none of the standard applications and functions provided by the cable company, he will still be using the cable company's domain name server, and when he goes on popular web pages, perhaps versions of them are stored on the company's cache. In the context of telecommunications services, the court recognizes a de minimis exception to contamination of telecommunications services by an information service. A similar exception would seem to apply in the functions in question here. DNS in particular is scarcely more than routing, which is expressly excluded from the definition of an information service. Yeah, Justice Scalia was really good at snappy language. He's really good at that. Finally, I must note that notwithstanding the Commission's self-congratulation paean to his degradation... Well, let me try this again. Finally, I must note that, notwithstanding the Commission's self-congratulatory paean to his deregulatory largesse, it concluded that the declaratory ruling by asking, as the court paraphrases, whether under its Title I jurisdiction, the Commission should require cable companies to offer other ISPs access to their facilities on common carrier terms. In other words, when the Commission hath given, the Commission may well take it away, unless it doesn't. This is a wonderful illustration of how experienced agency can, with some assistance from credulous courts, turn statutory constraints into bureaucratic discretion. You're speaking my language, man. The main source of the Commission's regulation authority over common carriers is Title II, but the Commission has rendered that inapplicable in this instance by concluding the definition of telecommunications service is ambiguous and does not, in its current view, apply to cable modem services. It contemplates, however, altering that outcome, not by changing the law, but by reserving the right to change the facts. Under its undefined and sparingly used ancillary power, the Commission might conclude that it can order cable companies to unbundle the telecommunication component of services, and presto, Title II will be available to them because they'll finally be offering the service. Of course, the Commission will still have the statutory power to forbear from regulating them under a different section. Such a Mobius strip reasoning mocks the principle that statutory constrains the agency in a meaningful way. Yeah. After all said and done, after all the regulation has been translated. After all said and done, after all the regulatory, I don't know what that's supposed to say, can't? Anyways, has been translated, and the smoke of agency expertise blown away, it remains perfectly clear that someone who sells cable modem services is offering telecommunication. For that reason, I would affirm. I'm like, yeah, alternate facts, right? There's that common saying that everyone's entitled to their opinion, but no one's entitled to their own facts. Well, apparently we were all wrong. You are entitled to your own facts. As I point out in dissent, this term means, under the laws, it's understood that many statutes ambiguities might be resolved in varying fashion by successive agency administrations will be resolved finally, conclusively, and forever by federal judges. Yeah. Producing an ossification of large portions of the statutory law. The court moves today to solve this problem of its own creation by inventing yet another breathtaking novelty, judicial decisions subject to reversal by executive officers. Yeah. Imagine the following sequence of events. FCC action is challenged as outside of their power under the governing statute. The litigation reaches all the way to the Supreme Court of the United States. The Solicitor General sets forth the FCC's official position, approved by the Commission, regarding interpretation of the statute. Applying Meade, however, the court denies the agency position Chevron deference, finds the best interpretation of the statute contradicts the agency position, and holds the challenged agency action unlawful. The agency promptly conducts a rulemaking and adopts a rule that comports with its earlier position, in effect disagreeing with the Supreme Court concerning the best interpretation of the statute. According to today's opinion, the agency is therefore free to take the action that the Supreme Court found unlawful. This is not only bizarre, it's probably unconstitutional. I agree, it is unconstitutional. As we held in a case, Article 3 courts do not sit to render decisions that can be reversed or ignored by the executive. In that case, the Court of Appeals had determined that jurisdiction to review an order of the Civil Aeronautics Board by awarding an overseas air route. By statute, such orders were subject to presidential approval, and the order in question had in fact been approved. In order to avoid conflict with the President's foreign affair power, the Court of Appeals concluded that will review the board's action as a regulatory agent of the Congress, and results of that review made subject to approval or disapproval by the President. As I noted in my dissent, the court bristled at the suggestion. Judgments within the power vested by the courts by the judiciary article of the Constitution may not be lawfully reversed, overturned, or refused faith or credit by another department of the government, as we recently saw in a case dealing with immigration, where the Immigration Board completely ignored a decision from the Court of Appeals. This is what today's decision effectively allows. Even when the agency itself is party to the case in which the court constructs a statute, the agency will be able to disregard that construction and seek Chevron deference for its contrary construction the next time around. Of course, like Meade itself, today's novelty is belated remediation of Meade creates many uncertainties to bedevil the lower courts. A court's interpretation is conclusive, this court says, only if it holds the interpretation to be the only permissible reading of statute, not if it merely holds to be the best reading, which is normally what courts do. Normally, what courts do is try to find the best reading, not any permissible reading, the best reading, the correct reading. This is the goal, as I understood it. Does this mean that in the future, statutory construction cases involving agency-administered statutes, courts must specify, presumably in dictum, which is a very funny and very biting point, because something in dictum doesn't have effect, right? It's something not necessary to the decision, which therefore are all court decisions. So now all court decisions are dictum because none of them are binding and none of them are authoritative. That's what the court said. So now all court interpretations are now dictum. Well, that was fun. Everything it says is dictum. Yay. Which the two are holding. In which of the many cases decided in the past before this dictum requirement was established? Apparently, silence on the point means the court decision is subject to agency reversal. Before judicial construction of statute, whether contained in precedent or not, may trump in agencies, the court must hold statute unambiguously requires the court's construction. How much extra work will entail for each court confronted with an agency-administered statute to determine whether it has reached not only the right result, but the only permissible result? Is the standard for unambiguous under the court's new agency reversal rule the same as the standard for unambiguous under Step 1 of Chevron? If so, of course, every case reaches Step 2 will be agency reversible. Pretty much, yeah. If so, does the victorious agency have the right to appeal the Court of Appeals judgment in its favor on the ground that the text in question was in fact not, as the Court of Appeals held, unambiguous, so the agency should have changed it to view in the future? Yeah. This sounds like some classic Scalia coming up next. It is indeed a wonderful world that the court creates, one full of promise for administrative law professors in need of tenure articles. And of course, litigators. I would adhere to what has been the rule in the past. When the court interprets a statute without Chevron deference to the agency views, its interpretation is the law. Yeah. I might add that there's a great mystery why any of this is relevant here. Whatever the stare decisis effect of AT&T is in the Ninth Circuit, it surely does not govern this court's decision. Yeah, no shit, right? Whatever the stare decisis effect of the Ninth Circuit is, we're the Supreme Court, so yeah. And despite this court's peculiar self-abandoning suggestion to the contrary, the Ninth Circuit would already be obliged to abandon the Portland holding in face of this court's decision that the commission construction of the telecommunications service is entitled to deference and reasonable. It is sadness that the court should go so far out of its way to make bad law, and I respectfully dissent. Word. As Higgins says, word. Right? So, over the past between last week and this week's stream, you now fully understand why Unky Blackleaf does not like Chevron, Auer, and Brand X. You understand why I don't like these decisions. Chevron says agencies can interpret statutes. Auer says agencies can interpret rules. And Brand X says agencies can change their mind and overrule courts. Right? That's what we've been reading for the last 2 sessions. That's what those 3 cases said. You have now read the language with me. You know I'm not making this shit up. I'm telling you what the law is. I'm also telling you I don't like it. I'm allowed to have an opinion. I don't like it. I don't think it's good. Here's what I think. I think the legislature should pass laws. And I think the executive should enforce those laws. And I think the judiciary should interpret those laws with the best interpretation it can. And if that wasn't correct, I think Congress should change it so that it becomes better. And I think agencies don't get some magic power to interpret statutes and interpret their own rules. That's what I think. I think, in fact, the courts should, in fact, ossify the federal law. That's my view. I think it should be ossified. I think it should be very ossified. I think the law means what it means when Congress wrote it. I think Congress had specific ideas in mind when it wrote it. And I think what a good judge should do, in my opinion, is do their absolute best to figure out what Congress meant at the time they wrote it. And then go do that. And if Congress wants something else, they can change their mind. So that's what I think. If I'm interpreting a law from 2019 or 1789, that's what I think. I think the judiciary should interpret the law and look at it and try their best to figure out what it means. And then that's what it means. And the executive then should go do that. And if Congress doesn't like that, then, pass a different law. That would be fine. So, yeah. It should have been 0 to 9. That's what I think. Should we do deep dive on the reasoning for the 6, not just the opinion we read? Just not the majority opinion? I mean, they concur in the result, right? So, I don't care. Besides, how many people were in that majority opinion? Hold on. How many people were in the majority? Let me quick find. No, that's the wrong case. I need this case. Huh. Is everyone in the opinion, and they just also issued a separate concurring opinion? Is that what's happening? Because I think that's what's happening. Which wouldn't be like unheard of. I think, if I'm reading this right, yeah. I think if I'm reading this right, because it just says that Thomas delivered the opinion in the court. It doesn't specify beyond that. So what that means to me is that all six, or was it six of them? Yeah, all six of them agreed with the majority. And so there's one opinion that has six of them, and then they also wrote separately as well, which is not that unusual. Yeah, so Justice Breyer writes separately to say that Justice Scalia gets Meade wrong. And Justice Stevens, what does he want to say? I don't know. Oh, it's really, really short. It's one paragraph. Here's the entirety of Justice Stevens' concurring opinion. While I join the court's opinion in full, I add this caveat concerning Part 3B, which correctly explains why a court of appeals interpretation of an ambiguous provision in a regulatory statute does not foreclose a contrary reading by the agency. That explanation would not necessarily be applicable to a decision by this court that would presumably remove any pre-existing ambiguity. Thus ends the decision from Justice Stevens. That's it. So there's nothing to say about the other opinions. So that's, yeah. Good times. Yeah. So all six of them agreed with the majority opinion, and two of them also wrote separately, which, isn't that unusual. They want to say something additionally. So, whatever. Justice Stevens, wrote 3 sentences. So that's fine. So, we all understand what's going on. What are we missing, Higgins? Well, if you figure it out, let me know, because I don't know. So, if you figure out what we're missing, let me know. Because I've been thinking about this for a little bit now. I read these decisions 15 years ago for the first time. I've been thinking about this for a little bit now, and I don't know what I'm missing. I don't know what I'm missing. I don't understand. I don't even necessarily object to the idea that a statute has ambiguity. But if it does have ambiguity, the court should be the one saying it's ambiguous. The court should be saying it has this range of flexibility. Because there are a lot of things that are ambiguous in the statute. So, the idea that ambiguity is not that crazy. But if there's ambiguity, it should be the court saying it. And then, if an administration comes along and says, hey, this word we think means this, then the court can analyze it based on precedent. So, that's that, I guess. So, how did you guys enjoy this episode of Supreme Court React? Was it everything you hoped for when you guys asked me to cover this case? Was this everything you hoped for when you asked me to cover this, and I read you the things, and we pretty much ignored the oral arguments because they didn't matter, which is kind of hilarious to me, because none of the oral arguments actually touched on the actual issues. So, did you enjoy this one? Chances I'm true conservative. Most conservatives are not. Thank you, Jan. I try to be. Yeah. I'll do whatever Congress wants. That's my role. I will do whatever Congress wants. They control the law, not me. So even more depressed than you would be. Hoping for more ranting. Well, you got what you got, man. You got what you got in terms of ranting, but yeah. Hopefully you're satisfied because, I have 12 viewers and 12 likes. That's good. Chevron, an hour that didn't matter. Brand X, they did a bit. Hence Scalia talking about it. Yeah. I don't know what Justice Thomas is thinking. What is Justice Thomas thinking? I mean, Justice Thomas is a hardcore originalist. He thinks it's a hardcore originalist position in view of Article 3. I mean, courts can only hear cases and controversies. If the agencies get to interpret everything, then I'd argue the courts actually don't have jurisdiction. Because why waste the time in the courts? Because just ask the agency what it means. Being anti-autocracy isn't partisan, is it? Autocracy? I don't think so. Yeah. I consider myself 2 steps away from anarchist on the liberal spectrum, and of course I agree with all this. That's funny, isn't it? Well, I guess it's not that funny because Scalia and Ginsburg were on the same side on this one. So it's interesting that someone on the right and the left also think that this is bullshit. So, there's that. Yeah. But I think it's a reasonably fair characterization to say, at least in legal jurisprudence. Because when you talk about left and right, I don't think those words mean the same thing in every context, right? So, like, you can say left and right in a lot of contexts. So, I think, at least as far as judicial philosophy goes, or judicial interpretation goes, I think it's reasonably fair to say that the left jurisprudence philosophy is for living statutes, living constitutions, living things that grow and evolve and change with time because of magic. And I think it's generally fair to say the conservative position is things mean when they were wrote and nothing, and that's it. So, yeah. Is there some opinion by Ginsburg you agree with or find really good law? I can't think of any off the top of my head, but that of course doesn't mean any. I mean, I know like what cases say a lot more than necessarily who wrote them. I mean, there's a few exceptions to that where I know like some things were written by some people, but I can't think of like any major Ginsburg decision that I like majorly agree with. But I was agreeing with Ginsburg like last time when they were saying stuff. So let's see if I can find some. Let's see if I can find major opinions from RBG and see if there's any out there that major decisions. Let's see if I can find some major decisions. 7 essential rulings. Okay, let's see what we got. United States versus Virginia, dealing with equal protection on VMI. Okay. Bush v. Gore. Bush v. Gore was just a total mess. And I think there's a good question to be had that it was Obergefell. Ginsburg didn't write Obergefell. Kennedy did. Why are they labeling this as a Ginsburg decision? That's not a Ginsburg decision. It's Kennedy's decision. Let's see if Wikipedia will give me a link to any major opinions. Notable cases. Hagedorn, Friends of the Earth, Bush v. Gore, Elred versus Ashcroft. No, I disagree with her on that one for sure. I thought the dissent had the better position on Elred. ExxonMobil Saudi. Which was one? This. Okay, Ledbetter versus Goodyear Tire. That was a dissent. So no, I can't find any major opinions that I really think are exceptionally great, but that by no means there aren't any. She's written a lot of opinions, so I'm sure there's several that I agree with. So I disagree that most people who call themselves conservative believe that things mean what they mean when they're written. Well, I did specify within the context of judicial jurisprudence, not just in general, because I think you can be conservative with respect to other things. So I don't know if you mean like most people call themselves conservatives generally, or most people call themselves conservatives as it relates to jurisprudential philosophy. Um, but yeah, Austin v. United States. Let's see. I don't know what the case said, so let me just check. Eighth Amendment applied to civil forfeiture. Did Ginsburg write that one? No. Austin v. United States was delivered by Blackmun. I didn't realize he was on the court that late. So that's not a Ginsburg opinion either. The 42K Land Rover civil forfeiture decision. Let's see which. Yeah, that if that was Ginsburg, I agreed with that one. Tim's. Yeah, so okay, there's one. Yeah, she wrote for that. She wrote that position. That was a unanimous position, so I agreed with that one. Yeah, I thought it was an excess fine. So yeah, I agreed with Ginsburg on that case. Yeah, yeah. Jan says I replied to Chusmas in that regard, but most people have a tendency to follow leaders, and we have bad leaders all around the world. That's true, and it's hard to be perfectly pure, myself included. I mean, I'm subject to my own biases and conflicts and everything else, but I try to think through stuff as much as I can. Largely, yes. It's my general observation that most people only identify as left or right based on highly personal reasons, support one or two policies. Fair enough. Well, I mean, evil tribble, that doesn't follow. Surely RBG wrote a 9-0 that's uncontroversial. I mean, we've been disagreeing with unanimous decisions this whole time, right? We disagreed with Chevron, that was unanimous, and we disagreed with Auer, that was unanimous. So we've disagreed with 2 unanimous Supreme Court decisions today, or between the last 2 streams. So yeah, that doesn't follow. Unanimous doesn't mean I agree with it. I think both Chevron and Auer were crap, even though they were both unanimous. So yeah, just because it was unanimous doesn't mean I think it was right. And wasn't Wickard v. Filburn in the MS too? I think it was. I think it was unanimous. Hold on. Was Wickard v. Filburn unanimous? I think it was. Yes, it was. Yes, it was. Wickard v. Filburn was unanimous too. So there's another unanimous decision I disagree with. So yeah, there's a couple unanimous decisions I disagree with floating out there. Yeah. Unanimous doesn't mean I think it was right. Yeah, Wickard was unanimous. I think it was wrong. Chevron was unanimous. I think it was wrong. Auer was unanimous. I think it was wrong. Yeah. 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 Yep. There's a lot of unanimous positions out there. I don't think you're right. All right. Well, anyway, since there's nothing else going on, RBG does usually write very well. Yeah, she does write well. She does write pretty well most of the time. Yeah, she's a good writer. She's a good writer. I'm also told she's a very fast writer still. So apparently she's pretty good in getting out her opinions pretty quickly. So whatever problem she has in speaking and enunciating these days, apparently she's still pretty sharp when it comes to writing. So, there's that. All right, well, I'm gonna kick the stream off and go to bed. And I hope you enjoyed this latest edition of Supreme Court React, as always. And I enjoyed spending my time with you. And I'd like to try to figure out ways to get even more people to join my streams. I mean, right now I have 13 concurrent viewers, and I'm grateful for all of you. But, I'd like to have 500 concurrent viewers. So if anyone has any great ideas on how to accomplish that, PM me on Discord or stuff. I keep putting out content and keep trying to improve my tags and SEO and all that good stuff. So we'll keep working on it. But, any thoughts, I would appreciate it. Till later, friends. I'm out. Peace. Bye.